We have a full house today. Good afternoon and welcome to the Appellate Division First Department. We have over 5.5 hours of argument time requested, so I am going to ask, as I always do, that you ask for only the time you actually need, not the time that you want. Understand that the clock is for you, not for my colleagues. So even if I only give you 5 minutes, and my colleagues still have questions, I will allow the clock to continue because my colleagues have questions, okay? So don't fret if I cut your time. Argue well, you'll get more time, okay? All right. People versus Holly Rockham. Okay. 4 and 1 and 4. Good start. Elias versus Elias. You want rebuttal?
Yes, Your Honor.
Okay.
Respondent would like
4, 5 and 1 and 4. C. Cameron is submitted. Muhammad versus Shea. Okay. 5 and 2 and 5. People versus State of New York versus Videre.
Oh, Your Honor, appellant requests 7 and 3 in response.
Okay. All right. 6 and 1 and 7. Black versus Phoenix Cayman. Okay. 6 and 2 and 6. And as I said, if my colleagues keep asking questions, you can keep going. Okay? All right. People versus William Smith. All right.
4 minutes, Your Honor.
All right. 4 and 1. You may end up with the 2. And 4. No versus Lynch. Lynch.
I'm here for respondent, Your Honor. Can I just have 1 minute, please?
Sure.
Thank you.
0 and 1 minute for response. Cortlandt Street versus Bonderman.
7 and 3 for appellate. There's also a cross appeal that I'm on, if you want, like 3 for cross appeal.
Okay. Okay. Go ahead. And you are?
For the respondent on the cross appeal, I'll guarantee 5 and 2.
You have a cross appeal or you're responding? Okay. You realize on both sides you only get 15 minutes. So I'm not great at math, but I think we're past that.
You're the only party opposing the appellant in the cross appeal. There are actually 3 parties responding to our cross.
Okay. All right, so let's do this.
Your Honor, excuse me.
Go ahead.
I represent one of the respondents, ATAX Partners LP. We request 7 minutes.
Okay. All right. And we are going to do the argument all at once, so we're not separating it. Okay, so make your arguments when you get up. 7 and 2, 7 and 2, 5 and 5. Okay. Rockoff Associates versus Village Place Corp.
Good afternoon, Your Honor. For the appellant, 6 minutes and 2.
Okay.
Respondent 5.
6 and 2 and 5. LMM Capital versus Mill Point.
Good afternoon, Your Honor. For the appellant, 8 and 2, please.
Okay.
Good afternoon, Your Honor. For respondents, Middle Point Capital and respondent Logistics, I request 5 minutes.
Okay.
Good afternoon, Your Honor. For respondent, Martin Kelly, 4 minutes.
Okay. 7 and 2, 5 and 4. Consolidated Edison versus East Coast Power.
Good afternoon.
Good afternoon.
Requests 5 and 4, Your Honor.
Okay, anyone here for the respondent?
Good afternoon, Jim Green for respondent, 5 and 3.
Do you have a cross appeal? Then you don't get rebuttal. Okay, so 5 and 2 and 5. People versus Trejuan D. Submitted. Kaufman versus Boys is submitted. Sokolova versus City of New York is submitted. First case on the calendar, People versus Holly Rockham. You may proceed.
Good afternoon, and may it please the court. Karina Scott, Center for Appellate Litigation, arguing on behalf of Mr. Rockham. Mr. Rockham's sentence of 6 years in prison and 10 years of post-release supervision is excessive and should be reduced in the interest of justice to 3.5 years on the
Your
incarceratory.
main argument is that there was no interview. There was no interview for the probation report.
Your Honor, our main argument is that the incarceratory sentence should be reduced in light of the mitigating factors, and one of those mitigating factors is that the probation department did not interview Mr. Rockham, and that had a prejudicial impact on the amount of mitigation.
So what effect is it then that there is a 730 report in the record that the court had, and the facts that are the mitigating factors and all other factors seemingly were addressed in the 730 report? Doesn't that cover the interview?
Yes, Your Honor. As you stated, there was plenty of mitigation in the 730 exam, including Mr. Rocham's struggles with a learning disability, his mother's psychiatric history.
Everything that an interview would necessarily reveal in the probation report, or if there were an interview by the probation department, correct?
Yeah, we agree that there is plenty of mitigation in the 730 report, and all of those mitigating factors that are reflected in the 730 report would act as a basis for the court to reduce this sentence, which is what we're asking for. We're just also noting that there's no doubt that there would be even more mitigation in the report had the pre-sentence report been fully completed. In addition, when at the sentencing, the prosecutor noted on the record that that Mr. Rockham had not been interviewed for the pre-sentence report, and the court responded by saying that it doesn't matter. So in light of that comment, it would...
Well, defense counsel also consented to proceed, because if defense counsel had objected and insisted on a probation report, the court would have had to adjourn the case for that purpose, no?
That's correct, Your Honor. And so that's why we're not asking the court to vacate this sentence. We're just asking them to consider as one of the many mitigating factors in this case that the pre-sentence report was incomplete. And
Wouldn't your argument rather support vacating? And you're not asking for that. The mitigation was there. The trial court was aware of it through the 730 report.
the trial court was presumably aware of the mitigating factors, but it seems like based on the comment and the dismissal of the lack of report that the court didn't take into account all of the mitigating factors. And some of those mitigating factors include Mr. Rockham's struggle with a learning disability, and also at the time of the offense, his struggle with substance abuse. There was a lot of evidence in the record that he was using K2, crack cocaine, and ecstasy at the time of the offense, and that is likely what contributed to this offense. He's a 34-year-old man with no prior criminal convictions and, importantly, no prior history of sexually motivated offenses, and so this conduct was aberrational, and that's underscored.
But I have to tell you, his act was one that was like the nightmare of every woman who lives alone, that they wake up and find some strange man in their room, not to mention what he was doing at the moment she awoke.
Certainly, Your
right?
Honor.
And so why is it not proper for the court to counterbalance the mitigating factors you speak of, which I am not poo-pooing, for lack of a better word, but his crime was one that is not one that you can just...
Yes, certainly, Your Honor. I mean, we don't dispute the seriousness of the offense. It was clearly a disturbing and bizarre act, but he is not a hardened criminal. He has no prior criminal convictions, no pattern of this type of behavior, and the very nature of the offense, concedingly disturbing. However, it shows that it was an act by someone suffering from a mental health crisis, and we just ask the court to take that into consideration. Because this is his first and only conviction, and his conduct was the result of crippling substance abuse in the middle of a mental health crisis, we would ask the court to reduce the sentence to 3.5 years with 5 years post-release supervision. Thank you.
Good afternoon. May it please the court, Faith Petrolio for the people. Defendant's sentence was fair and appropriate and should not be disturbed on appeal. As this court has already noted, defendant's crime was very serious. He was in multiple units in an apartment building, but most disturbingly entered the bedroom of a sleeping young woman and removed the tampon from her vagina as she slept, undoubtedly leaving her emotionally traumatized. I would also note the defendant was originally charged with 20 counts on the indictment. That was 12 felonies and 8 misdemeanors. And through this
But
plea
what
deal,
about the fact, as your adversary argues, the PSR report wasn't done and the court acknowledged that it wouldn't matter? That's what they said on the record. What view should we take of that?
well, as was already noted, those purportedly mitigating factors were mentioned in the 730 report. There's no extra mitigation that defendant points to now that would have been in a PSR versus the 730 report. And anyway, the seriousness of the crime would outweigh those mitigating factors.
The problem is that probation sentence report is utilized at the time of departure and discharge from prison. And not having one now leaves him without a summary somewhere where corrections can look to assess. He now has to depend on that they will actually go to the court record and pull that 730 exam in order to understand what those mitigation factors are. What do you say about that?
Well, as Your Honor already noted, defense counsel did not object. They proceeded without it. They're not asking for the sentence to be vacated at this point. And the purportedly mitigating factors were outweighed by the extreme seriousness of this offense. If there are no further questions. Thank you.
You have 1 minute.
Thank you. I just want to briefly address the people's argument that Mr. Rockham did not offer additional mitigating factors, but in the appellate posture, Mr. Rockham is confined to the record on appeal and only the record on appeal, and thus could not bring in additional mitigating evidence, and that is precisely why we highlighted the prejudicial impact of the pre-sentence report. And as Your Honor was getting at, in People v. Hicks, the court held that while there's no statutory requirement that Mr. Rockham was interviewed, the Court of Appeals has acknowledged that the pre-sentence report may well be the single most important document at both the sentencing and the correctional levels. So for those reasons, we ask the court to reduce this excessive sentence to 3.5 years, followed by 5 years post-release supervision. Thank you.
Thank you so much. Elias versus Elias.
Good afternoon, Your Honors. I'm Joseph Devanzo. I represent the plaintiff appellant, Jamie Elias.
Counsel, on this record, as I see it, your client just believed that her husband should pay all the legal fees, correct?
No, not necessarily.
Well, she didn't object to any of the bills.
She wasn't asked to object to any of the bills. It wasn't an issue that was presented to us so that we could object to the bills. The bills were not provided until the reply papers, nor was there any request for that.
You're saying she never received monthly statements of ongoing legal fees?
What I'm saying is that that issue wasn't before the court, and that
My
issue
question
wasn't addressed
was, are you saying that she did not receive monthly billing fees from the law firm?
I don't know the answer to that question, Judge.
Well,
That's at the crux of this issue.
I don't believe so. I think that
It absolutely is, because if you receive invoices on legal fees and you don't object, you are deemed to have waived it, to have accepted the amount that is therein. So it is absolutely relevant.
except in this case, Judge, she was told that everything would be resolved at the end of the case. That is, the amount of the legal fees and who would pay those legal fees.
well, counsel, I mean, the record has months of emails going back and forth where counsel is requesting an updated statement of net worth that we all know is going to be used to address any kind of pending, like attorney's fees or any payment. You really can't move forward beyond that. So how do we address that? I mean, it's months and months. Every email that your client sent, the response was, well, please give us this updated statement of net worth.
Yes, Judge. So two things. One is that it turned out that in the conversations that Ms. Jacoby Parisi had with the other side to try and get a voluntary payment of the attorney's fees, she learned that it was because of the carrying costs of the Fire Island vacation home that he was complaining about paying any more fees. So her strategy, which my client followed, was to wait until the sale of the Fire Island home, and then when that sort of carrying cost was reducing his expenditures, go after an agreement to get more fees. It turns
Except that
out
that's really not what the emails reflect, right? Why don't you file a motion? I can file a motion if you give us this updated statement of net worth.
and those efforts began at the end of 2021 after a December 15th conference with the court in which the court suggested that they try and work out an agreement. January, it became clear that the agreement could not be worked out. February, she started trying to make an appointment with the accountant in order to get the updated net worth statement, and then all of a sudden she finds out her lawyers are leaving the firm, and Mr. Rubel decides that he's not taking any of the cases or keeping those cases that those lawyers had, and she was one of them. And so she got jettisoned by the firm unceremoniously and without justification. There was no breakdown of the attorney-client relationship. The record doesn't support it. And so there was an unjustifiable motion to be relieved on the eve of trial.
If a client is not assisting you in preparing their defense or their case, what do you call that? Is that not a breakdown?
But she was. According to her affidavit, she was following her counsel's strategy, which is to wait until the Fire Island home was sold.
So she was doing nothing really during that time to assist the attorneys to prepare for anything.
Well, she was waiting for the attorneys to say that
You don't have to
negotiations had
wait.
failed.
Just because, you don't have to wait until the Fire Island home issue is resolved to start putting together the information that your lawyer needs so that the attorney's fees could be paid.
Except, Judge, there was nothing in the record that said, if you don't give us a net worth statement, then we're going to have to be relieved as counsel because you're not cooperating with us.
So,
It was never that
based on
ultimatum.
your arguments, anything that was not written in stone by the attorney's office is subject to scrutiny, but anything your client says happened, that we should take as golden.
No, Judge.
That's what happened, right?
Judge, I think what has to happen is there should have been a hearing in which both sides were heard and evidence was presented regarding whether this strategy, by the way, the attorney, Jacoby Parisi, put in an affidavit in the reply papers for the first time, and nowhere in that affidavit does she indicate a breakdown in the attorney-client relationship. The only thing she contests is whether or not she agreed to allow the fees to be paid at the end of the case.
Okay.
Good afternoon. May it please the court. My name is Eric Rubel. I'm a partner at Washburn.
Raise so we can hear you.
Sorry.
That's okay.
Counsel, let's start there with the affirmation of Jacob Parisi, who was the attorney that was interacting with Mrs. Elias. And in her affidavit, admittedly, it doesn't really talk about any breakdown in communication. It just talks about the fees. Does that really have any significant bearing as to the money that's owed here?
I apologize. I'm not following your question.
Well, your adversary just ended talking about the affidavit being submitted in the reply papers from the attorney who was handling the papers. Who was handling her case, rather. And one of the issues here is whether or not the relationship between the attorney and the client was irretrievably broken as to why they wanted to withdraw from the case. And I'm just asking you as to your take on that affirmation.
Okay. Thank you. The affirmation was part of a motion, but the history in the case demonstrates the long-term attempts by Ms. Jacoby Parisi to get her client to do a simple thing: update a statement net worth so that the firm could file an application for fees. I mean, there were three things that there was a contract here for a retainer agreement, and Ms. Elias acknowledged in those emails that she's responsible for the fees and she didn't want the fees going any higher. I mean, she says that in an email, which is an acknowledgement that she understood the gravity of the amount of fees that were
But
due.
she also essentially wanted Mr. Elias to pay her fees.
Absolutely.
That was her goal.
She had an entitlement. She felt that she had no obligation to pay the fees, except her contract that she signed with the firm. She was responsible. Now, there were three possible ways to pay the fees that were outstanding to the firm. She could pay them. The Fire Island proceeds that were sitting in escrow could have been used, or an application to the court, except Ms. Elias prevented all three. So there was no way for the firm to continue. If the client is not going to at least help facilitate the firm to be paid, and that was the crux here. That was the breakdown of the attorney-client privilege.
You actually, at some point, asked for the escrow funds to be used to pay part of your outstanding legal fees. Is that correct?
Yes, Judge.
And so the judge instead said, look, let's put a charging lien that'll be dealt with at the end of the case so that at least it didn't have to be taken out immediately.
It was to give her the ability to retain counsel for the trial, and I understood why the judge did that. I do want to make one comment about this alleged trial strategy and the escrow and the sale of the Fire Island home. That is the first time I'm ever hearing of this. It does not appear in the moving papers. It was never argued. It was not even in the arguments, or I believe in the record. So I'm not really sure why it even matters what the strategy was, except that that the monies were in escrow anyway, and she refused to use any portion of those fees to make even a partial payment.
I think your friend was pointing out that the affirmation in the reply from the counsel that was representing her didn't give off the impression that there was a breakdown in relationship.
There was a total breakdown in the relationship, and
Did the breakdown have to happen with Ms. Parisi? Or is a breakdown sufficient if it happened after she left and the remaining counsel at the firm unable to connect with this client and proceed forward?
in this case, the breakdown was occurring from the time that Ms. Elias refused to update the statement net worth. It didn't matter who it was with. She was refusing to do what the firm
My
needed
question
to do.
was actually a friendly question. Right? Because in my mind, whether the breakdown is with Ms. Parisi, right? And I understand Ms. Parisi kept on asking for updated financials so that she could do exactly what the client wanted, which was to move to have the attorney's fees covered by the husband, right? I get that. But Ms. Parisi didn't seek to withdraw. It wasn't until after she left and new counsel from the firm had to take over, and the client refused to pay even a little bit of the outstanding fees, that at that point, then everything broke.
And everything kind of came to a stop, and the two lawyers who managed the case for 3 years were no longer there. There was no one with the depth of knowledge to handle it.
Thank you.
Thank you, Your Honors.
Okay. And you have a minute.
Thank you, Your Honor. As far as it not being in the record, page 45 of the record, paragraph 12 of my client's affidavit says, I never refused to update my net worth statement. Ms. Jacoby Parisi recommended a strategic delay in making an application until after the sale of the Fire Island home.
But again, as I said earlier, making the application is one thing. That's taking the actual document into court and filing it. That didn't stop your client from providing her lawyer with the information so that when the time was right, they could hit the ground running.
Exactly, but there wasn't a refusal, and the record does not support.
Exactly what? She provided nothing.
No, she had an appointment with an accountant. She couldn't do it herself. She was having assistance, and in fact, the record
And after how
indicates
many times was she asked for that information did she make this appointment with the accountant?
that
How long had transpired? How many emails requesting that information had been sent by the law firm
it wasn't a-
before she made an appointment with the accountant.
It wasn't a constant strategy. Things changed over time.
Thank you.
Thank you, Your Honor. Oh, what, just,
Nope,
thank you.
thank you. Mohammed versus Shea. Mohammed versus Shea, oh, they're coming up, okay. Justice Pitt Burke is recused on this case. Should there be a tie, the court will follow the appellate division rules in that instance and vouch in a judge. You may proceed.
Good afternoon, may it please the court. My name is Natalia Kapitonova from Stuart Carlin Law Group, and I represent the appellant. This court should reverse the lower court decision because the medical board acted arbitrarily and capricious when it changed its own objective findings at the direction of the Board of Trustees, none of them who were medical doctors.
Yeah, but don't you think the trustees noting that the November 2014 accident was glaringly missing from the medical board's analysis of in determining whether your client was entitled to accidental benefits versus ordinary benefits? Is that something so beyond the pale when time-wise, almost all the treatment, surgeries, and inability, limited duty, et cetera, all occurred after the November 2014 accident and not after the May 2014 accident? Don't you think that's an important fact that should have been in that report?
Your Honor, two things about what you said. The first one is that the medical board was aware of the November 14 accident, and even though they were aware of that, they still found appellant to be disabled as a result of the Lodi accident. Regarding your second point, that she was on restricted duty and after the November accident, I will pinpoint you to the own responders exhibit, which is in the record, page 85, when it shows that after the May accident, which is a Lodi accident, she actually did not come back in full duty. She took a couple of days off, then she came, well, not a couple, I will say 2 weeks off, then she came back on limited capacity. Then she came back on full duty, or a couple of days only, again to go on limited capacity, and after all that, the November accident occurred. So I will say that the medical board had all the evidence, and actually there was no new evidence submitted after the Board of Trustees told them to give a closer look to the evidence.
Well, but part of the reason it was sent back was because the report did not seem to not even acknowledge that there had been a November accident, and the November accident resulted in serious injury to your client's shoulder, such that it necessitated a surgery, and your client sued for that accident, so that showing that she was indeed seriously injured as a result of the November accident. Why would it be improper for a member of the board to send it back to the medical board for reconsideration in light of those facts that I just stated, which were not at all addressed in the report?
Your Honor, because those facts were given by the medical doctors. It's one thing that they may not have articulated something, and another quite different thing is that they were not given all that evidence. They knew about the November 14 accident, they knew about the right shoulder injury.
Right, but it wasn't in the report. So the board that had to vote on it could not assess whether the medical board, whether they missed it, whether someone dropped the ball. Look at it again. I mean, sending remands happen not just from the board, but from this court. So that is not an unusual circumstance.
In response to that, Your Honor, I will say that what it was unusual is that one of the trustees, Cynthia Collins, who's not a medical doctor.
It doesn't matter. Stop right there. That doesn't matter. Doesn't matter. We have thousands of these cases with these boards, and not everybody on the board is a doctor. In fact, most are not. So that is not a basis to overturn this decision.
And I will not be asking it to overturn by her recommendation and her opinion that the car was not damaged enough. I will simply be saying that the doctors already made an objective finding. They were medical doctors. There was no evidence introduced. Once they reversed it, there was nothing else that was new for them to reverse
It was
the
an
decision.
incomplete, the first report, the way I look at it, was an incomplete report because it didn't mention, as my colleague's pointing out, the November 2014 accident. I mean, unless you're saying that it never occurred, that's a different story, but it did occur, and to have a complete record, to have a complete report, you'd have to have all the accidents, because from my notes here, the May 2014, after the May 2014 accident, the petitioner went back to work full duty, full time. That was in.
I'm gonna give you, since he asked you the question, go right ahead and answer. I'll give you a minute to answer.
A little longer than I
It's
wanted.
okay.
Thank you. The doctors did have all the evidence. That's number one. Number two, in the record, page 85 and 86, it says very clearly, here after the November 4 accident, the petitioner was sick for 11 days. After that, she came back on a limited capacity for 26 days. Then she came back for
You told us
17
this
days
already. We got that. There was back and forth, and then she had the November
She
accident.
did not come back on full duty, Your Honor.
Thank you. All right. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. I'm Alan Racines, representing the city respondents. Your Honors, I want to home in on this factual issue that was just being discussed. I think that my colleague on the other side is making an error about the record, and I'm sure it's in good faith. But if you look at page 85, which is the duty status history report, it indicates that after the May 2014 accident, the appellant went back to full duty, at first briefly. She goes back in June of 2014, then goes back off at the end of June, so mid-June to the end of June. But then after she's on limited capacity again for about 3 weeks, she goes back on full duty from July 23rd, 2014, until the accident in at the end of November 2014, on 11/25/2014. So she is actually on full duty for many, many months until the third accident, which is the accident that we say was the accident that led to her permanent disability, Your Honors. So that's just a mistake.
After that November 2014 accident, did she
Yes, Your
ever go back to full duty, or she did not?
She did not.
Until she
Did not.
retired. So that was, I mean, it may have exacerbated something from before, but that was the accident that caused the surgery and ultimately her desire to retire.
Right, Your Honor. I mean, whether or not it exacerbated it, certainly that final accident was the precipitating cause of her never going back to full duty.
Well, it doesn't even matter, but that final accident, you need to at least have some sort of discussion in the first medical report about it to really, I mean, they're the docs, right? They're figuring it out. Without that kind of, I mean, my notes said that it wasn't even addressed in that first report, right? So we don't know, I mean, we may have, it may not have, we don't know, right? So.
Yes, I agree completely, Your Honor. I think what happened with the first report was the medical board just seemed to overlook the possibility or the potential, which I think is actually a lot stronger than possibility, certainly the potential that the final accident, the November 2014 accident, could have been the cause of the permanent disability. I think there's also another important point to make about that first report, Your Honors, which is that it makes a very basic, and directly related to what we were just talking about, it makes a very basic factual error on page 44 of the record. In that first report, the medical board says that the appellant did not return to full duty after the May 2014 accident. Again, that's just wrong, Your Honors. So that was a basic factual error that the medical board made, which may be one of the reasons that they were confused on that first report. But that was the main thing. Those two things were the main thing that precipitated the remand, the fact that the medical board didn't consider the effects of the November 2014 accident and the fact that the medical board just...
Well, I guess they may have gotten it right, but they forgot the intervening accident, right?
That's right. That's exactly right, Your Honor.
That's
Yes.
because we know that she went back to full duty in May of 2014 after that accident. That was the full duty. So when they said that she never went back to full duty, they're missing something in between.
Right, that's exactly, Your Honor. That's exactly right, Your Honor. So
So you would agree that the trustees have a responsibility to ensure that there's a fully developed record, correct?
I think that's right,
That's why
and
they asked
also,
to take another look-see, because they noticed this November 24th accident not in the report. It wasn't a question of overreaching and coercion. It was trying to do the right thing here.
that, I agree completely, Your Honor. Yes, I mean, it was a question of making sure that the medical board considered everything that was in the record, including this very big thing that they seemed to overlooked, which is, this was it seems to have been a major accident, Your Honor. Remember, the standard review here is just some evidence in the record supporting the pension board's determination. It was, which is cleared easily here, I think, by the agency, because this was the November 2014 accident. What happened there was the the appellant's personal car was T-boned. So it was, this was not a minor accident, Your Honor, T-boned from the
Whereas the
passenger
May
side.
accident was a rear-end collision, which I understand from the record, maybe $45 worth of damages on the car.
Right, that's the other thing, Your Honor, and that gets to the final point I would make about the remand from the pension board to the medical board. The pension board noticed that there was this report that it thought might be new. I actually don't think it was new, but it wasn't clear whether the medical board had it when it was making its first determination that showed, I think the report said, quote, minor damage to the car. It's on page 371 of the record. So that also, I think that's a less important fact here.
It would
It's
not
another
be
fact that's worth
unusual for the board to send this back if they determine something like that, would it? I mean, that happens in your proceedings.
I've seen it happen before, Your Honor. In fact, I've seen other cases. I had a case where it happened multiple times, so where the pension board remanded to the medical board multiple times. So, yeah, I don't think it's uncommon.
My quick question is, if we were to agree with the appellant here, that would mean that we're essentially saying that the trustees have no right to send something back, that they can't remand anything if they find that there's a little discrepancy or there's a problem, right? I mean, that's what it boils down to for me.
I mean, I think that's right, Your Honor. I think that the important point to make, jumping off of that, is there is no evidence, despite what the appellant is arguing, that there was any compulsion on the part of the pension board to say to the medical board, you have to change your determination. The pension board, and you can look at the written remand on page 370 of the record, Your Honors, the pensions board said, reconsider. And that's what's reflected in the minutes that written remand refers to. You have to think about this final, basically saying to them, you have to think about this final accident and assess what effect it had on the disability. And that's all it was, Your Honors. It was not some sort of mandate from the Board of Trustees by any means.
Thank
so
you.
with that, we ask for affirmance, Your Honors. Thank you.
Thank you so much. You may proceed.
Okay, Your Honor. So the first point is that I don't believe I made a mistake because I did explain that the appellant went back after the second accident on full duty some days. I was just explaining that not the whole time she went back on full duty. Also, if we only focus on the fact that she tried to reintegrate to the workforce after the second accident, and Your Honors hold that because of that she should be denied accidental disability, then the court will discourage anyone that has a low-day accident to try to reintegrate to the workforce. I think it's a good thing that she tried her best to try to come back on full-time duty. She didn't succeed all the way, but she tried some days. And on the third, yes.
You heard what my concern is that if I were to accept your argument, it seems like we would be saying, or at least saying out there, that there's a restriction on what the trustees are able to do when there's something wrong in terms of the medical report. Is that a concern that's real?
Well, I disagree, Your Honor, because I'm not arguing that the trustees don't have the right to remand something. Certainly, all the trustees have the right to remand a decision. What I'm arguing here is that there was no evidence for them to remand it. They directed, basically, the medical board to hold otherwise based on the same decision. It will be another thing if they said, you did not have the information about the third accident. Please look again and make the decision. The medical doctors had all that information.
But why was it wrong for them to say, we know you had the information, but it isn't in the report. So we're sending it back, assess the information that's there, and tell us what your recommendation is once you've incorporated those facts into this assessment. What's wrong with that?
What's wrong is that the medical doctors explained very thoroughly how she
Except they did not explain away what impact the third accident had. That's what was missing, right?
certainly
What was missing.
certainly, Your Honor, they did not believe that the third accident was a career-ending
But they didn't
accident
say
because
it.
They could
But
have
they
said
didn't say it. If they had said, we know she had a third accident, but that's to another part of the body and it has nothing to do with her back problems, that's one thing, then I might agree with you. But they said nothing. So I don't see why the board would have been, why it's improper for the board to send it back and say, there's other information, it's not in this report, tell us how that accident plays on this case. But we heard you. Thank you.
Okay, thank you,
All
Your
right.
Honor. Thank you.
People versus State of New York versus Vidaire. You may proceed.
Good afternoon, Your Honor. Frederick C. Kelly on behalf of Appellant Vidaire. May it please the Court. 3 points I'd like to make. First, state law presumptions cannot, for a long time now, be used to mask constitutional violations by state actors. That's classic bedrock principles under the First Amendment that the Attorney General never challenges. 2, the retaliatory animus that animates the subpoena has been conceded by the AG. 3,
Where is that conceded by the AG?
that was conceded, Your Honor, under the summary judgment standards, 3212.
Excuse
me?
If there are facts,
I didn't hear what you said. It was conceded where?
right, so when there are no contested issues and a court is hearing a summary proceeding on the papers, just deciding it on the record, the standard there is 3212. It's well established that under 3212, CPLR 3212, facts that appear in the moving party's papers that are not challenged are deemed admitted.
This is not a 3212 motion, is it?
No, but because
Okay. This, we are here to determine whether it was proper to compel compliance with a subpoena ducis tecum. That's what we're here for.
right, but that's a summary proceeding. And if the summary proceeding is being decided on paper, the standard is identical to 3212. So that hermeneutic, if you will, is applicable here. If we allege facts, and they're not met, and we're not the only ones who allege them, by the way. They included the facts themselves in their own moving papers and never met them.
Counsel, I want to get back to certain basics. Would you agree that VDARE is subject to the non-for-profit law?
Yes.
Would you agree that under the non-for-profit law, there are state regulations that determine money that comes in and how it's spent, and that it should be spent appropriately? Would you agree?
Of course, Your Honor.
Okay, so now we have a situation, and I'm just drawing one tidbit out of the record. So when there's information that suggests that, for example, 1/3 of the operating budget of this non-for-profit was used for the salary of one of the major principals of VDARE, that would be sort of like a red flag. You would agree that at least that concept, say it's unproven, but just to be able to investigate that, would that be some kind of an anomaly for the Attorney General's office to investigate it, which is what they're charged with doing in these sort of cases?
That may be an anomaly. Maybe not, too. And maybe that gives rise to an investigation, but not this investigation. You don't need this territorial 40-category subpoena to investigate that allegation, nor do you need that.
But that's not the only allegation, right? We also have the purchase of a castle, which is a massive piece of property, allegedly bought purportedly for the purposes of having a meeting house for VDARE, but has been used as the personal home.
Incorrect, Your Honor. That's incorrect.
That is what the allegations are, right?
Those allegations were known to be false at the time they were raised, all right? And
Say you.
well, says the record.
Say you. The OAG says something different.
Okay, so then
That's why
still-
we're here, right?
so still then you need an investigatory subpoena tailored to those facts. You don't
Right,
need.
so
The
that the-
court did.
Go ahead.
I mean, the court did, you're saying that the subpoena may have been somewhat overbroad. But the court did tailor the subpoena to focus on certain things. There were obviously conversations, there were certain agreed upon redactions. There were things that were worked out after this subpoena was put out there. So that happens all the time.
No, very minimally, Your Honor. And frankly, one does not jump from, gee whiz, one might have misused the real estate of the charity to, okay, give me your anonymous writers. Give me all your anonymous writers and go through 1 million pages of email for me. If you want to investigate the castle transactions, fine. We're ready to, we tried laying
Was
open
there not
castle
some sort of compromise made in terms of the identities of sponsors? Right, the OAG walked that back, that part of it back, right?
There was no accommodation made for paid writers, which are the bulk of the anonymous writers on VDARE. There was no accommodation made for them whatsoever. In fact, the AG kind of made conflicting representations to the federal court and then to the state court. But they initially said, we don't want any content creators to the federal court. And then in state court, they turned around and said, oh no, we want them too. There are problems with this castle transaction. Therefore, give us all your anonymous writers. It squarely, it violates core First Amendment principles here, and it is crying out for judicial review, which has not occurred yet. And I think, respectfully here, to bring it back, there was a great debate between Justices Harlan and Brennan back in the 60s, back in the 50s and 60s, when the court started getting more serious about protecting freedom of speech and association. In Harlan, in NAACP versus I think it was Buttons, indicated that the only reason the court was protecting the free speech and associational rights.
Finish your thought. I'm allowing you to finish your thought.
Thank you very much. The only reason the court was protecting the freedom of speech and associational rights was because of the ideological bent of the NAACP and the racial politics that surrounded it. And Brennan came back and said, no, absolutely not. Absolutely not. The law here is being applied even-handedly and would apply to anyone, no matter their ideology or their race. I respectfully submit that this case, with Letitia James on one side and VDARE and Peter Brimlow on the other, is a perfect opportunity to vindicate Justice Brennan.
Thank you.
Thank you, Your Honors.
You may proceed.
Thank you, Your Honors. Excuse me. May it please the Court, Andrea Trento from the Office of the Attorney General on behalf of the state respondent. The Court should affirm the AG's investigation was reasonably related to a proper subject of inquiry. There's no evidence of bad faith or retaliatory animus advanced in this case, and the requests satisfy the exacting scrutiny
What's your response to your friend's argument that you've conceded the retaliation argument?
Your Honor, there's no merit to it whatsoever. On the first point, the allegations that we've supposedly conceded appear in a federal court complaint and are conclusory. The complaint alleges that the AG's office conducted this investigation for retaliatory purposes. There's nothing to respond to, frankly. In any event, we did respond to that. The first thing that we did was argue in state court that this complaint asserts allegations. It was in the context of VDARE's motion to stay the state court proceedings so that the federal court proceeding could proceed. We argued against that, obviously saying there's no reason why those allegations cannot be litigated here in state court, which is hardly a concession, I would say. The other point is, at oral argument, we did specifically deny those allegations, and they're conclusory, and so beyond simply denying them, there's not much more evidentiary-wise that we could have done. So that's the point there. The council made several kind of discussions about the scope of the subpoena, referring to over 40 categories. We hear that, we see that a lot in their briefs, but it's their burden to come forward and say, here's what the categories are, here's why they are overly broad. The point that was litigated in the trial court below didn't have anything to do with the scope of 40 categories. It had to do with narrow issues that were in dispute at the time. The identities of VDARE's vendors, not just its writers, but anybody that VDARE has contracted with and paid money to. Yes, Your Honor.
But the bottom line is that the subpoena provides for redaction and protection and anonymity.
The court invited the parties to.
So they're concerned about harassment and chilling their associational rights or chilling their First Amendment rights by virtue of this investigation. Based on the way the order is structured, just can't be.
The court below invited, and the state is willing to enter into a protective order that would restrict certainly the state's opportunity to use any information turned over in this case that the VDARE deems confidential in other contexts, certainly to disclose it. And so we would.
And that has been the center argument, that they don't want their writers, either paid or anonymous, to be harassed.
They point to situations in VDARE's past where contractors have refused to do business with VDARE. Now, it's not clear whether it's because their identities were disclosed or it's because these contractors exercising their own First Amendment associational rights with regard to associating with VDARE. So the record's not clear on that. But in this case, VDARE cites several cases. They cite the Arista Records case from the Second Circuit. They cite the Doe versus Hochul case from state court, or I'm sorry, from federal trial court, saying that these are First Amendment disclosure of identities raises First Amendment issues. And both of those cases involve litigants who wish to proceed anonymously because of the risk to them from disclosure. But both of those cases also involved protective orders that allowed the other litigants to discover the identities of those parties. The courts in those cases deemed that sufficient to address those First Amendment issues. There's no reason why.
And that's what the court suggested be done here, right?
That's correct. That's what the trial court suggested be done here. There is ample factual basis for this investigation. The Castle transactions themselves. Now VDARE raises issues.
That wasn't what started this investigation, right?
There are several facts publicly reported facts that started this investigation. One of them was the fact that this castle was acquired by VDARE and then became apparently the residence of several of its directors. And so that raised questions about the use of charity funds and charity property for the benefit of individual directors. The other issues include the compensation paid to Mr. Brimlow, again, one of the directors. Mr. Brimlow pays himself, or VDARE pays Mr. Brimlow through an entity called Happy Penguins LLC. There is disclosure about the amount of Mr. Brimlow's salary paid by VDARE, but VDARE pays his LLC tens of thousands of dollars more than what his compensation is disclosed as. And so that raises other questions about, again, self-dealing by the directors of this organization to themselves. There is the issue about the numerous filings that VDARE made, and in some cases didn't make, or untimely made, with both the IRS and with the state, that raised questions as to whether VDARE understood how to deal with related parties. In some cases, they failed to list related parties on those forms where they were required. Yes, Your Honor.
So you've just detailed a litany of different things. The argument that maybe it's retaliatory and your adversary had attached letters from the governor, reports from Facebook, are those red herrings, that that's not what we're supposed to be paying attention to here?
Your Honor, there's not a single statement that they can point to by anyone at the state about VDARE or its alleged hate speech. The only people complaining or talking about VDARE's hate speech in this case are VDARE. The AG has said nothing about that. The AG is right now investigating a charity that appears to be engaged in transactions that at the very least raise serious questions about the organization's compliance with New York law. Another point that counsel made about the scope of the investigation having to do with many gigabytes of emails. This was an issue that came up approximately in October when VDARE's counsel represented the state that I've also isolated 40 gigabytes worth of email that need to be reviewed. And at all points during that process, it was represented to the state that he could have that done in 2 or 3 weeks. And so we're now hearing for the first time, there was no effort at that time by VDARE to say, is there a way we can maybe come up with some search terms or identify specific custodians to try to narrow that down. There was no offer, no request by VDARE at that time to make that kind of a narrowing, ask the state for that kind of a narrowing effort. We're hearing about that here for the first time on appeal as an argument for why the subpoena, this court should send the subpoena back and have the trial court go through every category. It was not an issue that was raised below.
Thank you.
I see my time is up. Thank you, Your Honors.
You have a minute.
Your Honor, there's no evidence that this is not a hate speech inquiry. What about record 267, 271, and 324? This was the first of not one, but 3 subpoenas launched against VDR's information. And the first 2 came from Rick Sorick, Special Counsel of Hate Crimes. Sorry, Your Honor.
No, that's okay. The judge mentioned in her opinion below that you had been partially complying with subpoenas for months, so now they just wanted you to provide a redaction log for some of the documents you've already been produced. So you have been doing some compliance with their subpoenas, no?
Without a doubt, Your Honor, 6,000 pages were produced. What we've objected to was we can't produce our anonymous writers, we don't want to produce our vendors who wish to remain anonymous, and we don't want the burden of going through 40 gigabytes and millions of pages of email. But if you want to inspect the castle transactions, we've tried to meet with you about the castle transactions. If you want to discuss Brimlow's compensation, that's fine. And they want to talk about the basis for this investigation. But if you want to know if there's been insider dealing, you know who the insiders are. You've got 4 or 5 people. We can go through who they are and who their related parties might be. That's a much more discreet and narrow inquiry than this monstrous subpoena, which cannot stand under the First Amendment, let alone Article 1, Section 8 of the New York Constitution. Thank you, Your Honors.
Thank you so much. Black versus Phoenix Cayman. You may proceed.
Good afternoon, Your Honors. Rachel Carriage on behalf of the plaintiff appellates. May it please the court. The appellants have filed this appeal because the Supreme Court erred in its decision and order dismissing respondent as a party defendant from the case below. First, the trial court erred in dismissing the respondent for lack of personal jurisdiction by improperly applying a heightened standard for specific jurisdiction. Second, the trial court erred in dismissing appellant's fraud and conversion causes of action on a merits basis. In its dismissal of the fraud claim, the Supreme Court wrongly concluded that the fraud allegations were attributable to a different defendant, Vishal Garg, and not to the respondent, even though the respondent worked in concert with defendant Garg on pre-investment activities that give rise to the fraud claim. With respect to the conversion claim, the Supreme Court erred in finding that the amended complaint failed to identify the funds that the respondent converted within a 3-year period before the action was commenced. Now, I'd like to focus on specific jurisdiction. The trial court incorrectly applied the standard for general jurisdiction in holding to establish specific jurisdiction. Plaintiffs must make the requisite showing of continuous and systematic activities by a defendant in New York which show that the defendant was availing himself of the privilege of conducting business in New York and the protections of New York law.
Why is that incorrect?
That's incorrect, Your Honor, because under CPLR 302A1, an attendant case law that governs specific jurisdiction, that case law and the statute dictate that one transaction in New York is sufficient to invoke jurisdiction, even though the defendant never enters New York, so long as the defendant's activities here were purposeful and there's a substantial relationship between the transaction and the claims asserted.
Right, and so when we're talking about international parties, you know, emails and phone calls and things of that nature may or may not, depending on what they say or how consistent they are or how purposeful they are, we'll, you know, use that word. Why is that not present here?
Why
is it?
I'm sorry, Your Honor.
Okay.
Well, we do think that the purposeful contacts are absolutely present here. There's a plethora of emails and phone calls, all from Mr. Vicious Warren, who's located in the UK, to the partnership and the subsidiaries, all which are operated out of New York, all of the employees are located in New York, and the other director of all the other entities that's responsible with Mr. Vicious Warren for running this partnership, Mr. Garg, he's located here in New York. Now, I think because these contacts really can't, these purposeful contacts cannot be disputed, the respondent has largely contested whether or not there's a nexus between those contacts and the claims in this case.
Right.
And as we've argued in our opening brief and in our reply, each of the appellant's claims against Mr. Vicious Warren have a nexus to New York. Beginning with the appellant's fraud claim, the evidence is clear that the respondent worked in conjunction with defendant Garg, and the other partnership employees, as I just mentioned, are based here in New York. They worked together on the pre-investment diligence. They worked on the pre-investment pitch. And then throughout the life of the partnership, Mr. Vicious Warren continued to work with these employees and specifically Mr. Garg on the operations and finances of the partnership. Now, with respect to the conversion claim, that's tied to New York because the $5.25 million that was wrongfully converted by the respondent was derived from settlement proceeds in a New York-based litigation for a success fee that should have been paid to the partnership's wholly owned subsidiary, Prez. And again, Prez's operations are here in New York. Instead, those funds were transferred to Mr. Vicious Warren's personal bank account.
From New York?
No, Mr. Vicious Warren is located in the United
No, I know he's in UK,
Yes.
but I'm saying the money was transferred from New York?
Yes, Your Honor, that's my understanding. Now I see that my time is coming to a close, so I also want to focus on separately.
That light says 2 minutes left, okay? So when it first
I've got a
goes
lot
out-
here, but I'm trying to be efficient. Separately, outside of those issues attendant to specific jurisdiction, the lower court's holding should be reversed because jurisdiction was established over the respondent by virtue of the form selection clause in the LP agreement.
But he wasn't a signatory, I'm sorry, I always get the name wrong. Vicious Warren wasn't a signatory to the LP agreement, correct?
That's correct. And New York law holds, and I believe this is the
And if I'm not mistaken, that was, the forum was the Southern District. Am I
Well-
correct? And we have case law that just because you're hailed into a federal court in New York doesn't necessarily mean you're hailed into a New York state court.
I agree and I disagree. Under the LP agreement, yes, it states the Southern District of New York. However, basic law states that you have to have subject matter jurisdiction to get into New York. Regardless, the services agreement doesn't have specifically SDNY. It says generally the state,
Even
courts
if
of the
we
state
can
of New York.
get past the jurisdictional issues, do you survive anyway on statute of limitations?
Yes, Your Honor, we do. On the fraud claim and also for the conversion, well, specifically on the conversion claim, the principle of equitable estoppel is applicable because of the major concealment efforts that Mr. Vicious Warren in concert with the other employees and Mr. Garg employed, which we pled in the amended complaint. But on the fraud claim specifically, the appellants exercised reasonable efforts to try to find out what was going on in this partnership for years. And they could only have a mere suspicion that any sort of fraudulent activity was going on.
How do you,
Good.
how do you address the judge's finding in his decision in the motion court that Mr. V's activities predated the partnership formation and therefore they had no nexus to the conversion and the waste claims?
So with respect to the conversion claim, that is equitable estoppel, and we would have never found out that the $5.25 million was taken from the partnership, but for the lower court's decision in discovery mandating that the defendants produce documents and an accounting and the books and records for the partnership. We had no idea about the actual sum certain of the amounts that were taken, but within the amended complaint, it was pled that the incentive fees and the administrative fees were wrongfully converted. The appellants at the time, they just had no idea the amount because that information was being concealed. Now, with respect to the corporate
We'll
waste-
have time on rebuttal because you're out of time.
Okay.
All right.
Good afternoon, Your Honors. May it please the court, Chris Harwood for Mr. Vicious Warren. I want to start with answering one question, which was where the money was transferred from, and it was the Cayman Islands. It's not clear to me that that's in the record, but that is the answer to the question. There is no substantial relationship between the claims the plaintiffs have asserted and the alleged New York contacts. The plaintiffs' claims are twofold. There's a fraud in the inducement claim that's based on Mr. Garg's, not my client's, Mr. Garg's alleged statements to induce the plaintiffs to invest in March of 2011.
But that was based upon a PowerPoint, which I think your adversary is alleging that your client, well, that Mr. V had a lot of input into creating that. Maybe he didn't have contact with the investors directly, but
I think when Your Honors, right before coming here and preparing, I reviewed all of the emails that my adversary cites. And when you look at those emails, the emails speak for themselves as opposed to the characterization. My adversary focuses on two emails. One was an August 4th, 2010 email in which Mr. V responds to a New York-based analyst's concerns about the investment opportunity, right? That's 7 months before the PowerPoint presentation. It's at record 348. Mr. Viswas-Warren writes in full, not quite the entire picture. The deal is for an investor group to purchase it for a ROM with us appointed manager with annual revenues. The investor group makes money on two fronts. Firstly, by increasing the management fees, which we are discussing with Maiden Lane, and secondly, through resids. The danger to the whole concept is that the CDOs are completely worthless and written off. That's why we need to stress test assumptions. And then, 7 months later, there's an email exchange, March 7th, 2011, in which Mr. Viswas-Warren forwards to the same New York-based analyst certain pitch materials that Mr. Garg had sent to a non-plaintiff investor. That's what Your Honor was referencing. It's at record 352. And there, Mr. Viswas-Warren writes in full, materials on Phoenix for review. What's your landline so that we can go over the details? Else you and Vishal can discuss. Now, from those two emails, or others that are even more innocuous when you look at them, plaintiffs are suggesting that Mr. Viswas-Warren engaged in conduct directed at New York, and that substantially relates to their claims. They're arguing that those claims, the claims are the fraud and the inducement, but those emails don't support an inference that following the completion of the due diligence, 7 months later, that Mr. Viswas-Warren had any concerns about the investment opportunity, much less that he believed.
You never answered my colleague's question
Yes.
whether Mr. V was one of the instrumental people who put together the PowerPoint.
So that is
the answer to that question yes?
The answer to that question is I don't know. It's not in the record. All we have is an email where he's copied the email that I just quoted.
There's a lot of discussion in the email going back and forth about a lot of work putting together this PowerPoint. And you and I both know that this PowerPoint was the instrument that was used in order to cultivate investors, to get them to invest their money in what was basically really bad mortgages, repackaged to pretend to make them better. And they weren't any better. They were, as Mr. Johnson said at page 348, this is garbage, right? They have no value. And so they've been repackaged, resold to new investors, right? Take junk, let me put a new bow on it and sell junk, right? And somebody put that package together in a PowerPoint. Why is that person not at least in part responsible here?
So the investment opportunity was successful. The plaintiffs' investors got fully repaid. This is about whether they're entitled to more money than they got.
How long did it take for them to get repaid?
They got repaid on time. They got repaid by 2014. They were fully repaid. The email traffic reflects that Mr. Garg sent the PowerPoint, that Mr. Viswas-Warren was copied on it. Sure that he discussed it, but in order to substantially relate to their claims, they would have to reflect that he had some reason to believe that there was some issue with it, that there was something wrong with it. The claim is fraudulent inducement, that Mr. Garg made misrepresentations. There's nothing to suggest, first, that there's a misrepresentation in there, but second, that Mr. Viswas-Warren somehow understood or believed.
He was stating in those emails, Mr. V was stating his opinion as to whether or not what was given to him was accurate and how maybe things have to be reassessed, right?
He was just saying we need to diligence, and that was that one email. Yeah, we need to stress test all of this, and presumably the stress testing happened. The end result was the PowerPoint, and there's nothing to suggest that
Ultimately,
Mr. V had any problem with it.
Garg either ultimately whatever he did, he could have just like, I'm not listening to Mr. V. I'll do whatever I gotta do.
Yeah, I mean, at the end of the day, if there were misrepresentations, Mr. Garg, there was certainly nothing in the record or no allegations, no documents to suggest that Mr. V had any misgivings, had any understanding, had any questions. But also, that's also the problem with the fraud claim on the merits. And in terms of the time-barred nature, both the fraud claim and the conversion claim are absolutely time-barred. The plaintiff's own factual allegations.
You're about to run out of time. I'm going to give you keep talking because
Thank
I
you.
want to hear your answer on
In
this.
2011, they alleged that Mr. Garg misrepresented that plaintiffs would receive distributions every month. They allege that was a misrepresentation of fraud in the inducement. They allege in 2014 they stopped receiving monthly distributions. They allege in 2014 that they stopped receiving financials and other info to which they were entitled. They allege that their inquiries were thereafter, repeated inquiries were ignored. That is fact sufficient to put a reasonable investor on notice that there were misrepresentations made by Mr. Garg, allegedly, to induce their investment. And they did nothing, and they waited 6 years, and the statute of limitations had more than expired. And the same as the problem exists with the conversion claim. They've got to establish equitable estoppel for the conversion claim. What they have to apply that, they have to assert that my client, Mr. Viswas Warren, engaged in an affirmative act that caused them to delay filing. That's the requirement for equitable estoppel. They got to allege my client did something, and they've pointed to nothing. All they point to in their brief is the May 2020 investor call that my client participated in. They say he made misrepresentations. They just assert that, but they don't actually identify any misrepresentations that he made. And they certainly don't identify a misrepresentation that caused them to then delay in filing suit. Their complaint alleges that the call merely raised more questions than it provided answers. If that's really true, if that's their takeaway, then they should file suit. There's nothing that caused them, certainly not from my client, to delay. Thank you, Your Honors.
All right.
Your Honors, just briefly, with respect to the investment strategy, it was not successful, or else we would not be here today and there would not be a proceeding before the lower court. And the lower court wouldn't have really recently denied summary judgment in its entirety when...
The question becomes, how much was Mr. V involved in that investment strategy? Like, what did he do and how much did he partake in that sort of PowerPoint that Garg ultimately, put before your clients, right?
So from the record that is before this court, he engaged significantly. What is important in any sort of deal of this type is the pre-diligence investments work that's done. Mr. Vicious Warren...
The question I have is that any of the emails that he responded to, that any of the statements that he wrote in those emails, were those wrong? Were they fraudulent, or were they just his view or his idea of, as a money guy, that's where it should go?
Well, as part of the pre-diligence analysis, he actually pointed out that the entire investment strategy in CDOs might be, and I quote, worthless. Knowing that they might be worthless, nonetheless, he knew that that presentation was going out to investors, not saying that, hey, there's this risk that this entire investment strategy is going to be worthless. Quite the contrary, it said, hey, this is a great investment strategy, invest in this equity residual. In fact, he was part and parcel of that same investment presentation going out to
if I buy your argument that he says it's worthless and Garg does the presentation and takes an opposite approach, why should Mr. V be on the hook? He's the one who said, look, man, he's sounding the alarm bells, and Garg himself takes the opposite approach and says, this is great. He's going to be making everybody fantastically rich.
Well, Your Honor, I have two answers to that question. One is actually in our brief. That's the Fletcher case. In actions for fraud, corporate officers and directors may be held liable if they participated in or had knowledge of the fraud, even if they did not stand to personally gain. But here we can even take it a step further because Mr. Vicious Warren did personally gain. He got $10,000 to $15,000 in director's fees every single month for staying involved in this partnership. He got $5.25 million in funds that should have been sent to the partnership that went directly into his pocket. Thank you.
People versus William Smith. proceed.
Clara Hammond Oakley on behalf of Appellant William Smith. Your Honors, I'm asking this court to find that the SORA court erred in their point assessments and also to grant
Counsel,
Mr.
Even if we were to agree with you that the points assessed were improper, that would still put him at level 3. So how would he survive a downward, what's his argument for downward departure? How do you survive that third gelati factor?
Yes, Your Honor. So that was actually the point that I wanted to start with, was the downward departure factor for that exact reason. Mr. Smith should get a downward departure in this case because defense counsel below proved his active and excellent engagement in 3 different areas of programming, all of which reduces risk of recidivism. The first was
excellent, or is that what he was supposed to do?
It wasn't what, Your Honor, if somebody goes to sex offender treatment program, they can sit there and they can get average scores, they can get below average scores, they can not participate, they can not take a leadership role, and they can still pass it as they're required to do by docs. However, Mr. Smith did much more than that. He was scored as above average, he was described as highly motivated, and he did achieve a senior coordinator position within the therapeutic community. He didn't have to do that. He did that because he wanted to better himself. In addition, the vocational training that he didn't have to do that either. However, he did, and he put a lot of effort into learning those useful skills that would help him when he was released. He was described as excellent. When he was transferred to a different facility and began doing horticulture there, he was described as a person who has suggestions that he's providing to the crew at this new
Counsel,
facility.
I'm sorry.
Yes.
Just as a side point, didn't the defendant receive 2 Tier 3 disciplinary sanctions?
I believe that's correct.
And I believe it included violent conduct, fighting weapon involved, drug possession, and smuggling?
Yes, Your Honor. From the board summary, it seems like he did receive 2 sort of sets of tickets at 2 different times. First, I would note that he did receive a 12-year prison sentence in this case. So I don't think that it's unusual for somebody who's in custody for that long to receive some number of tickets. Additionally, the sheer number of tickets...
You're saying it's not possible for someone to actually do well in prison and not do this stuff?
Oh, certainly I'm not saying that it's not possible. However, I'm saying that I don't think that getting some tickets, especially tickets between just 2 incidents, doesn't seem abnormal. It doesn't mean that somebody didn't have good conduct when they were incarcerated. Additionally, I would note that one of those instances, many of those tickets seem to arise from a single day. I don't know the backstory about those tickets. However, it does seem clear that they were one single incident that a number of tickets came out of.
I thought on the record they made note of 4 Tier 3 and 7 Tier 2 disciplinary sanctions. It's not
Yes.
just 2 little tickets.
And they describe them occurring on two dates only. Your Honor, Mr. Smith was scored 0 points because the court decided that even with those tickets that did not represent him behaving badly while he was in custody. In addition to the horticulture program, Mr. Smith participated in numerous educational programs to try to gain skills that would help him when he was released. His teachers described him again as doing well, said that he showed tremendous growth in his academics. He is a very diligent worker, and his scores reflect this. Now, all 3 of these programs were designed by docs. They're designed and offered by docs to lower people's risk of recidivating when they're released. There's studies to back up the fact that they lower someone's risk of recidivating once they're released. And so showing that Mr. Smith excelled in those programs shows that he does represent a lower risk of recidivating, and that should be represented in his ultimate risk assessment at this hearing. Going to Your Honor's point, it's true that if we were to win on this points issue, we would not get to a level 2. However, he would then be at the lowest possible level of level 3. If you look at the points here, 0 to 70 is 1, 70 to 110 is 2, and then 110 to 300 is level 3. Mr. Smith would be either way is far down at the end, and if he didn't have those 15 points, would be just on the cusp.
Yes, counsel, but what he was convicted of?
Yes, Your Honor.
Is so just beyond the pale that one has to really consider these cases very, very carefully.
I agree, Your Honor, and I would just like to also note something that I think sometimes gets lost in SORA. Mr. Smith pled guilty to those charges. He was sentenced to 12 years in prison
and his
for those
9-year-old
charges.
cousin and his 13-year-old cousin who bore his child have to live with it for the rest of their life.
Yes, Your Honor, and
right? So, we all have to live with the consequences of these kind of cases.
Yes, Your
But
Honor,
you'll
and-
have time on rebuttal.
Thank you.
Good afternoon, Your Honors. ADA Saad Siddiqui on behalf of the people of the State of New York, Bronx County District Attorney's Office. May it please the Court. Your Honors, I would just start off with respect to the second point that the defendant raised on appeal with respect to the downward departure. I would note that although the defendant relies on Gillotti, Gillotti also very clearly states that even if the court finds that a defendant's conduct is exceptional, not excellent, not above average, exceptional, it must still be weighed against the totality of the circumstances, the totality of the defendant's conduct. In this case, it is very clear that the totality of the defendant's conduct was abhorrent. Making it very clear, let's look at the totality. The defendant, who was acting as a babysitter to his 9-year-old and 13-year-old cousins. His 9-year-old cousin, he raped and orally and anally sodomized. His 13-year-old cousin, he raped, impregnated her, and then this 13-year-old child was forced to bear her rapist's child herself. Notwithstanding all of that, he then, looking at his other conduct, racked up numerous arrests. He was convicted in 2008 and 2006, subsequent to when I believe he was charged or pled guilty to raping his 13-year-old cousin, of other offenses, drug-related offenses. And on the same day that he pled guilty to this offense, these offenses, he also pled guilty to promoting prison contraband. That was borne out by the record in the case summary. And to really appreciate the magnitude and the totality of the defendant's conduct, I would point to the case summary, which specifically, and I'm referring to it here, where it says that the defendant pled guilty to rape in the second degree, course of sexual conduct against a child in the first degree, in full satisfaction of the additional charges of 9 counts of predatory sexual assault against the child, 4 counts of criminal sexual assault in the first degree, 2 counts of course of sexual conduct against a child in the second degree, 2 counts of rape in the second degree, and I can go on and on and on. And to the extent that opposing counsel refers to the fact that the defendant acknowledged responsibility, of course he did. He received a tremendous benefit by virtue of the sentence that he received, which ran concurrent to the sentence he received on the promoting the welfare of promoting prison contraband charge that he pled guilty to. That notwithstanding, I would also point out that the people's position is that the defendant was properly assessed the points under risk factor 11, the 15 points there, notwithstanding defendant's claims to the contrary. But even if this court were to find that those points were improperly assessed, he is still a level 3, and this case does not merit a downward departure, especially in light of the fact that the victims in this case were children. Thank you.
Thank you.
So, Your Honors, the board is very clear that there is not a list of, an exclusive list of factors for which a downward departure is warranted. There's no way to list all of the factors in advance. While they do provide that somebody's exceptional response to sex offender treatment is one such factor that could be considered, that doesn't limit a person's conduct in every area to have to be deemed exceptional or be called exceptional by somebody writing a report or something like that. What we are saying here is not just that Mr. Smith excelled, did very well, actively participated in sex offender treatment. We're saying that he did that in 3 separate areas, all of which are intended and demonstrated to lower someone's risk of recidivating. Additionally, Your Honor, I don't believe that Mr. Smith's last arrest, or earlier arrest prior to this case, he was arrested in 2013 here. Before that, his arrest was in 2008 for a drug-related crime. I believe it was criminal sale of marijuana. He was not arrested after this case for any drug-related offenses. I I would just like to take one moment just to emphasize.
I'm not stopping you. Go ahead.
Thank you. This is a risk assessment instrument. This is not further punishment. The only reason why we're talking about whether or not Mr. Smith is a level 2 or a level 3 is because of the conduct he was charged with. Prior to this arrest, Mr. Smith did not have a sexual criminal history. He did not have a violent criminal history. The only reason that we're talking about Mr. Smith being subject to lifetime registration requirements is because of exactly the concerns that Your Honors mentions. And he, despite being charged with this, the courts have said that he still is entitled to due process. He's entitled to an accurate point assessment, and he is entitled to a downward departure if there's evidence showing that he is not pose the highest level of risk to this community. So in light of all those facts, Your Honor, I would ask you to correct the points determination in this case and grant him a downward departure.
Thank you.
Thank you.
No versus Lynch. You've been very patient waiting for your little minute. Go ahead.
Good afternoon, Cheryl Corman, on behalf of the Hockey League defendants. Plaintiff here was simply not entitled to an insanity toll. While she claims she was unable to function in society, the evidentiary proof that even she puts forth, if we can even call it that, demonstrates otherwise. She was an adult woman who lived alone with a roommate.
The question is, does she qualify as a disability on the 208, right? I mean, that's the bottom line.
Exactly.
And there was no medical support affidavits, anything put in?
Absolutely not. The only thing put in support was her ER records, which indicated she had a concussion. She was released after 3 hours. Her Glasgow coma scores were 15 out of 15.
Her own expert found her cognitive abilities pretty good. She actually went back to work.
Yeah, exactly. Well, she went back to work, and she also drove for the 2 years after.
She taught, right?
She taught CPR.
Yeah.
I think
to agree with
we've been thinking about this case. I'm sure. How come there was no assumption of risk defense here?
we never even got into that. We are just here because she blew the statute of limitations, even
you
if we
didn't
were
have
to
to reach
apply
that
the COVID toll. So we didn't even get into the merits here. So, and I also just want to point out that any issues that were raised in connection with the COVID toll have been clarified since the underlying briefing. So under any circumstances, the case is time barred.
If we were to agree with the appellate here, that'd be really stretching the disability portion of 208 to, I mean, uncontrollable bounds, right?
Essentially, she sustained physical injuries. We're not saying she did not sustain physical injuries, but there are absolutely no mental injuries that are associated, and she absolutely functioned in society. There's nothing here indicating otherwise. So really, unless the court has any questions,
no,
I did it in under a minute.
Thank you so much.
Thank you.
Portland Street versus Bonderman.
Good afternoon, Your Honor. Before we begin, and so to take no one's time away, I just rise to introduce, I'm Peter Wang of Foley & Lardner, here to introduce my partner and colleague, David Goroff, member of the Bar of the State of Illinois. The court has granted his application to argue pro hoc vice.
It is granted once again on the record. Welcome. Okay, and you may begin. You have 7 minutes.
Good afternoon. My name is Paul O'Connor for the TVG-related entity appellants, the sole remaining defendants in this one-count lawsuit for alter ego judgment enforcement. I have 3 points I'd like to address this afternoon. First and foremost, the Court of Appeals in its seminal Morris decision made clear that an alter ego claim requires specific evidence against each defendant of 2 things. 1, complete domination and control, in this case of the 2 Hellas judgment debtors, Hellas 1 and Hellas Finance, in connection with the challenge transaction, and that's important. The domination and control is supposed to be in connection with the challenge transaction, which here is the December 2006 recap, and, not or, and use of that complete domination and control to commit a wrongdoing or fraud. Here, as I understand it, it's alleged misstatements in the offering memorandum for the recap. Now, importantly, and we've cited this, complete domination and control is more than simply control. It has to be something more than simply that there's a corporation and it's controlled by somebody. All corporations are controlled by somebody. There's shareholders, there's directors, there's whatever there is, there's a controller. And so simply controlling is not complete domination and control. And you have to go beyond that, and there has to be a use of that complete domination and control to commit a wrongdoing or a fraud. And the Court of Appeals in this very case, at the motion to dismiss level, made clear that once they were past the motion to dismiss level, the plaintiff has to show, quote, each individual's daily conduct and involvement in the fraud. Each individual's daily conduct and involvement in the fraud. This court's East 34th Street decision holds the same, as do numerous others. The trial court ignored this requirement in denying summary judgment and then instead used a so-called collective liability standard that, and frankly, I think was sort of invented by WTC and bought by the trial judge. And I will get to that shortly. But sticking with what should have been done here, it's beyond dispute that WTC has not made and cannot make either of the two alter ego showings as to any of the TPG entity appellants. Indeed, the only connection that some, but not all of these appellants have to this transaction in 2006 is that some of them received distributions as a result of it, and some of those distributions were large. But that's not relevant to either prong of the alter ego analysis, although they ride that horse pretty hard. All one needs to do to see the lack of evidence here is to look at pages 14 to 17 of WTC's opening brief, where it lays out the so-called evidence, and I'd urge the court to look there. It's 3.5 pages after years of discovery, millions of pages of documents produced, and dozens of depositions taken primarily in Europe, none of which supports either prong of alter ego, most of which is inaccurate, but in any event, it's wholly irrelevant data about some of appellants having an indirect investment in the Hellas Group. Indeed, it's clear that WT's strategy on appeal, as it was in the trial court, is to try to confuse the situation with often wrong, but wholly irrelevant in any event, statements about Company A having interest in Company B, in turn had an interest in Company C. Sometimes they throw in the word controlling, sometimes they don't, but none of it has anything to do with either prong of alter ego, which is all that's left in this case. This case has...
There was some argument about consortium theory, doing away with corporate formalities, using the same office space. How do you address those kind of things?
Well, sure. I think every one of those factors actually supports the dismissal of the WTC, of the appellants from this case. None of those prongs, those are the Pasquale factors that the court went through, and none of those have anything to do with the appellants here. I mean, for example, corporate formalities. Did Hellas and Hellas One and Hellas Finance follow the corporate formalities? Well, the evidence in the record is that they did. But most importantly, for purposes of alter ego here, there's absolutely no evidence that any of the appellants here had anything to do with the Hellas One or Hellas Finance, much less making sure that they were maintaining corporate formalities. And
There's
the rest,
about 7 or 9 TPG defendants here. Is there some difference in what some of them do? I mean, would there be one, for instance, may just have an office. Others seem to have more involvement. It seems to go up a chain, and I'm just trying to figure out. I know you think we should dismiss everybody, but
Sure.
Is there any distinction here I should?
well, so when you get to the 9, the fact of the matter is all 9 of these are similarly situated, and I believe the dismissal is appropriate to all of them for the same reasons. And it is confusing. There were a lot of different entities here, including the reason that these entities don't belong in an alter ego case here, again, and the reason that there's no evidence about them is these are U.S. investment funds and their advisors. All these funds did was they passively invested in this Hellas investment. That's all that they did. They were located here in the United States. They invested passively. Now, this was a transaction that was done in Europe by European advisors, by European lawyers, by European auditors, by banks located in Europe. It was performed by people living in Europe under European law, and significantly, remember, 2 European courts have already taken a look at this. So the European defendants who have been dismissed from these cases have been subject to trial in Luxembourg and in London. And in both of those trials, they prevailed, and the claimants lost.
Now, initially, the Apex Partners Fund, was that a completely different setup than your TPG people were?
Absolutely.
Because they were let out and you were kept in, and I'm trying to understand what was.
There were TPG European entities that were dismissed on personal jurisdiction grounds. There were Apex European entities that were dismissed on personal jurisdiction grounds as well. But they are 2 totally separate private equity houses, one located in London, one located here in the United States in Fort Worth and in San Francisco. And again, the distinction as to why these 9 are left is because They were here in the United States, subject to jurisdiction in the court here, and they were not dismissed on personal jurisdiction grounds. And then again, we moved for summary judgment. We moved to dismiss, obviously, as well on the alter ego grounds, but we didn't prevail. But then we moved for summary judgment. And respectfully, the trial court simply, at WT's urging, followed the wrong standard here. And what they did is they not only did they try to lump all of the TPG entities that are left together, but incredibly, they also tried to lump us together with non-parties to the case, with Apex entities that have been dismissed from the case, with TPG entities that have been dismissed from the case. I mean, this is taking a collective liability theory beyond anything that I've seen in any context, much less alter ego. And maybe I'll switch kind of quickly to what I think is my second point, which really is that the doctrine here of collective liability is not something that exists in the alter ego context. It doesn't exist. There are no cases that stand for it. The two cases, the Second Circuit case and this court's case in Perez, did not do what these folks told the trial judge happened. Nobody put everybody together and just said, well, you know, entity A did something and entity B didn't do anything, so I'm going to make entity A and B face trial. Somebody did something. What they did is that in each of those cases, they looked through, and the defendants that stayed in the case did something. In the Second Circuit case, it was a directed verdict, and what the court did was left some of them out of the case and said and sent others back for a retrial in the trial court. Obviously, taking a look at who did what and when, just as the Court of Appeals said ought to happen here. This is to be done defendant by defendant. You can't simply lump everybody together, and in particular here, where they're trying to lump us together with non-parties. You know, it would be one thing if all of the TPG appellants that are left in this case did something together, had some involvement either in dominating and controlling the Hellas entities and using that domination and control to commit a wrongdoing. But they didn't. And again, getting to the wrongdoing, and I think it's important to take a look at it, the alleged wrongdoing here is the offering memorandum. Either there are misstatements in there, a very complicated one about Luxembourg CPECs and whether they were properly described. I think they were, but that's not relevant for today because it doesn't matter. The TPG appellants that are left in this case had nothing to do with that offering memorandum. There is no evidence anywhere that they had anything to do with the offering memorandum, even in those 3.5 pages of so-called evidence that they think supports this billion-dollar case. They don't even mention the alleged wrongdoing. The wrongdoing, according to them, is an offering memorandum that was put together by advisors, issued under the name of banks in Europe. And I think it's important to note that this whole OM is a bit of a straw man here, because you realize that behind WTC stand distressed debt investors who bought this stuff for, I think it's cents on the euro. It's not pennies on the dollar. I think it's cents on the euro. But in any event, they weren't concerned with the offering memorandum. This company was sold in early 2007. It performed and serviced its debt in 2007 and in 2008 and in 2009. It defaulted in late 2009. Obviously, that was during the time of the global financial crisis, which hit Greece particularly hard. Then the company failed. It defaulted on its debt, and the people the PIC note holders who stand behind WTC bought again in the aftermarket for pennies on the dollar. So the concept, we had nothing to do with the offering memorandum.
We'll have time on rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. David Goroff on behalf of Respondent WTC. Your Honor, Mr. O'Connor peddles a lot of fiction there, so let me try to unpack that as much as I can. Let's look at the particularized facts about the 9 TPG defendants, because all of them have...
Before you get to that, is it your position that all the TPG defendants stand in the same shoes, or can you parse some of them out based upon what they've...
No, you can actually parse them out a little bit, but I think there's a case for all of them, as Justice Reed found after 8 hours of argument, 2 days of hearing, 150 exhibits. But certainly, for example, there are 3 that are co-owners with their apex counterparts of the Hellas entities, and those are TPG Partners 4 and T3 Partners 2 and T3 Parallel 2. And then there are 4 which are general partners and managing agents of those funds, because the funds don't act for themselves. And those are TPG Advisors 4, TPG Advisors 2, TPG Genpar 4, and TPG Genpar 2. There's something called the Duchovny letter, which Justice Reed emphasized, which is in the record at 4373-92. And it shows the error of what Mr. O'Connor just told you. In there, as Justice Reed emphasized, it said that the consortium described the judgment debtors as, quote, intermediate shell companies, which were, quote, controlled by the Apex entities and TPG entities and are not independent from these controlling entities. That counsel went on to the SEC. This was an SEC letter. TPG entities to include GPs, general partners, and managing agents, noting they were, quote, overseeing and controlling the investment of billions of dollars committed to these funds. And that's at 4374 and 75 of the record. Besides, TPG Partners 4 received $380 million out of that dividend distribution, something Mr. O'Connor has never addressed, never confronted, never talked about. It was not the only one. 5 others received monetary benefits as well, including T3 Partners, $47 million, T3 Parallel, $8.7 million, T3 Gen Par 2, T3 Gen Par 4, and TPG Advisors 4. So, Justice Pittsburgh, to answer your question, those are all clearly deeply embedded in this transaction, but so are the other 2. So the other 2 are TPG Capital, which regularly received consulting fees on all of the things that were done, including contemporaneous with this transaction. And it provided a logistical.
Wait, hold on a second. You're proceeding against the defendants on the alter ego theory, correct?
Correct.
So the fact, maybe I misunderstood, the fact that they're getting money or gotten distributions, what does that have to do with the alter ego?
Because money gave you money was because they had ownership, and ownership is what the locus was of control. They had 50% of ownership. The Apex entities did, and as Justice Reed found, there was a consortium that jointly exercised control. And contrary to what Mr. O'Connor has said,
So you're saying you're taking off all the alter ego requirements then?
Not at all. The Passalacqua
You gotta, well, if you don't tick off all the alter ego requirements, how are you gonna get them then?
Because you can exercise control jointly. You can exercise domination jointly. Look at Passalacqua. There was no whole ownership on one entity. It was spread among 15 parties. There were 7 entities, 8 individuals.
So I'm trying to figure out, sort of as a follow-up to Judge Owen's question, so how was there domination and control? Even all together, I mean, because that's what we have to do. I mean, I know all these interactions are, I don't know if I should say interesting, but they're interesting. But the thing is, now we're down to, we have a judgment, and you would like to obviously get something back on that judgment.
Exactly.
And where's the domination and control?
So it's exercised collectively, and the domination or control is because they exercise.
So he said, and maybe Mr. O'Connor's wrong, that there really is no collective liability concept within the alter ego theory. Now,
Well, he is wrong. What he's trying to do is collapse 2 different theories. One is the notion of group pleading or lumping.
I'm going to ask you to move over a little, because you, like me, talk with your hands, and you're going to hit it. Okay.
One is I'm sorry. It should be a conductor. One is the notion of group pleading or lumping. And that is where you don't have particularized facts, as I took you through. The other is the notion of joint liability, and we see that in joint tortfeasors. We see that in...
But not in alter ego sense.
You do see that. You do see that. We cite the Linkers case. We cite the Fang. We cite
Every single fact pattern has a little uniqueness to it, though.
I disagree, Your Honor. I mean, there are numerous cases. In the Passalacqua case, which is the seminal case, out of the Second Circuit, but applying New York law, has been applied 43 times, I believe it was, by the New York State courts. And it spread it out among 15 parties. And that's what we have here. If I may get to the cross appeal, because here, Justice Reed made amply supported findings as to each of the TPG defendants. There were a couple of errors he made as to Apex New York and the 2 individuals, Collie Chain Aliberti. As Apex New York, it was not, there is a difference. It was not a direct owner, and it did not get direct payment. What it was instrumental to the consortium, because without it, you wouldn't have been able to lure investors who were interested in knowing the telecom expertise of TPG and Apex. For Apex New York's telecom deals were what were showcased, and those were Yell, Jamdat, Intelsat. Also, Justice Reed missed critical evidence implicating Apex New York. He said that Apex New York had no relationship with any European entity. That's incorrect. Apex New York was a partner in and owner of Apex London, which was the investment advisor to the two Apex funds, Apex Europe funds, that were the named owners. So it participated in the Apex London entity. He also, Justice Reed also said that there was not a single email or other communication sent or received by a representative of Apex New York. Actually, Apex New York CEO John McGrew attended the meeting where the dividend was approved and received the minute for that in an email. Colleague and Aliberti were the deal team leaders and responsible for the entire levers of power. They were Hellas One board members, they were Hellas...
But they were not shareholders.
I'm sorry?
They were not shareholders.
They were not direct shareholders. They did get distributions of $300,000 apiece, which I believe is significant under the law, but they were not shareholders.
Thank you. You'll have time on rebuttal. Okay. No. Not yet. No, not yet. Who's next?
You may want to hear what the other folks have to say.
Yeah.
Good afternoon, Your Honors, and may it please the Court. Robert Fischler for Respondent, Apax Partners LP, which has been referred to in this case as Apax New York in order to distinguish it from various European entities, including Apax London, which you've heard some reference to today. In granting summary judgment to Apax New York, Justice Reed did not merely reject the claim, but he held that, quote, "It is clear that there is no basis for the claim." He was right. The evidence is uncontroverted that Apax New York had no ownership, interest in, or other relationship with either of the judgment debtors. It played no role whatsoever in the challenged transaction.
Can you?
I was going to say, the fact that you got money doesn't mean that you're in.
We didn't get any, Your Honor, and I agree with you. I was about to say my third point was not only didn't we play a role, but we received zero proceeds. And that's uncontroverted. I think there's some attempt to confuse that, but I agree with you. That is not strictly liable to alter ego. You have to remember there were claims in this case for fraudulent conveyance and for unjust enrichment, which tried to unwind the transfers to any number of the defendants. Apax New York, though, having said that, received zero proceeds. And I point that out not because I in any way disagree with your observation, but simply to underscore the distance between this entity and what happened in London, in the UK.
Can I ask you, what about you're a private equity fund, just like TPG is a private equity fund. So how did you get out and they not get out? What was the distinction while you're out and he's in?
I can't tell you, Your Honor, what Justice Reed was thinking about in terms of distinguishing Apax New York from the TPG entities. It may be the point that Justice Owing has been talking with us about in terms of, they received, some of the TPG entities received money. The Wilmington made a big deal of that in front of Justice Reed, just as they do here today. I don't know. The Apax Fund, though, and this is a critical point, the Apax Fund was not managed or advised by Apax New York. It was advised by the separate UK entity that's referred to in this case as Apax London. That's where Mr. Aliberti worked. So not only is it uncontroverted that Apax New York played no role whatsoever in this transaction, there was no reason for it to play a role. It makes perfect sense that it didn't play a role because, as Wilmington admits at page 70 of its opening brief and elsewhere, the investment advisor to the Apax Fund that invested in Hellas was not Apax New York. It was Apax London, a separate and distinct UK entity.
Was there any, is there any weight to the fact that maybe Apax New York had some sort of minority interest in Apax London?
Your Honor, I can state unequivocally that Apax New York did not have any indirect, direct
minority interests. They owned 0 shares. They did not hold a stitch of Hellas debt. There were no overlapping officers, directors, other personnel. There was no relationship whatsoever. They didn't even have an arm's length contractual relationship. The Wilmington says in its reply brief on page 2 that Apex New York was a shareholder, or that it had, oh no, excuse me, in footnote 14 of their reply brief, they make the bold assertion that Apex New York had an indirect ownership interest, and I think counsel may have repeated that today. That is absolutely false. They do not cite to the record. That's footnote 14 of their reply. There is no citation to the record because the record doesn't support it. There is no support. Record 7869, paragraph 9. That is the affidavit of John McGrew, who is the Apex New York CEO at the time of the transaction. He states unequivocally, straightforwardly, Apex New York had, quote, no ownership interest, period. And that's why it didn't get a cent from this distribution. But in any event, it did not have one, Your Honor. I want to just go to a question that Justice Kapnick asked before, because I think it really cuts to the core issue in the case. And Justice Kapnick asked about control and domination. I would say to you, Justice Kapnick, that while Wilmington in its briefs speculates about Apex New York having played some role, they don't deign to tell us what role they think that was, but they speculate about an unspecified role. What they don't do is ever address the fundamental question in this case. What did Apex New York do that constituted complete domination of the judgment debtors and the use of that domination to commit a wrongdoing? What did they do? The answer is nothing. After years of discovery, of extensive discovery, you have 16 volumes of an appellate record here. There is not a scintilla of evidence of Apex New York doing anything. Counsel points to the fact that Mr. McGrew attended this meeting in London where he says the transaction was, quote, approved. Look at the minutes. They cite the minutes. It wasn't approved there. This was a meeting of an Apex London committee with a deal team in London. Mr. McGrew was not a member of either committee. His reply affidavit, paragraph 3, speaks directly to this. He was physically present in a single meeting waiting for another meeting to start. This is the quality of the evidence that they are talking about in asking you to make Apex New York, an entity that had nothing to do with this transaction, stand trial on a $1.2 billion alter ego claim. That's a frivolous position. Apex New York never belonged in the case. It doesn't belong in the case now. We respectfully ask that you affirm Justice Reed. Thank you.
Thank you. All right, up next.
Good afternoon, Your Honors. Anthony Candido for respondent Mr. Aliberti. As Justice Kapnick observed, there are a lot of entities, a lot of parties, a lot of things going on in this case, so I think it might be helpful just to situate Mr. Aliberti. He is not a shareholder in any of the judgment debtors. He is not an officer in any of the judgment debtors. Mr. Aliberti was an investment professional at Apex London, which has been mentioned, was an investment advisor to the AE6 fund, which then invested in the Hellas parent. The judgment debtors are below the Hellas parent. They're the guarantor and then the issuer. The guarantor was the parent of the issuer. Mr. Aliberti, for his part, worked and advised in Apex London on the deal.
He was connected with Apex London.
He was connected with
Apex
Apex
London is out of the case, but and at the moment, so is your client, Mr. Aliberti.
Correct.
So it's kind of like a double level of trying to find alter ego. The company is already out, then how would Mr. Aliberti get back in?
Aliberti's out.
No, but how, I mean, they think he should be back in, don't they?
You know, well,
That's why you're here.
For the life of me, I don't know. That is why we're here. He was, here's his connection. He was a director, one of 6 members of a board of the Hellas parent, okay? The Hellas parent as an entity was what's called a manager of the issuer, okay? And then as a director of the Hellas parent, Mr. Aliberti voted on some resolutions in connection with the recapitalization transaction. So essentially what they're hoping to do is hold him liable individually for this billion-dollar judgment of the issuer and the guarantor, of which he's not a shareholder or an officer. He's one of 6 members of the Hellas Parent Board who, as an entity, acted as a manager of the issuer. That's his role.
You're asking us to disregard several corporate forms to get to your client.
Absolutely. He is so many levels up.
To
And-
hold
and-
him
and
personally
all-
liable for $1.3 billion.
Exactly, Your Honor. And all he did was director stuff. He voted on
Every
resolutions.
director in this country will start shaking in their boots. if you agree.
Absolutely. That's our point. He had, I mean, not only that, but he had absolutely no ability as one of 6, members of a board of directors to exercise dominion or domination of these judgment debtors. He did nothing like that. Obviously, we cited a lot of case law about the Walkowski decision. He did not act in his individual capacity. He acted in his official capacity as a director, and that's all he did. And so, we respectfully submit that the lower court got it right.
Okay, thank you.
Thank you.
All right. Now you go.
I just want to pick up really quickly to make sure that I don't miss it on the cross appeal where we represent Mr. Calice, who is Matthias Calice, who is situated identically to Mr. Aliberte. They played the same role. Mr. Calice lives and works in Europe. He worked for something called TPG Europe. He advised
He's
on.
out right now, right?
He's out of this. He's out of this case.
Individuals
They're
were-
trying to bring him back in. It's the same multiple levels of alter ego. And we joined in the briefing that was done by Mr. Candido to try to at least limit the paper a teeny bit here. And I'll join in the arguments that were made as well. I think that
2 pages worth is all.
I know.
he's out and he should stay out. Well, 2 pages is if everybody did 2 pages, it would be a lot of paper. So in any event, I'll move on now from that. From what little time I have left, I really think, to be honest with you, Mr. Garoff made my point. What he said is the reason that these 9 TPG appellants belong in this case is because they had some control or some ownership of something. He was talking very fast. I think he was referring to some Hellas entity. It doesn't matter. Having control and ownership is what corporations do. They control and they own things. That's why they exist. They're limited liability corporations. That is a recognized concept and not a frowned upon concept in this court or in anywhere in New York, certainly not by the Court of Appeals and not by this court, I know. So he's proved my point. They don't have the domination and control because you can't simply say, I get to go to trial on a $1.2 or $1.3 billion case simply because somebody owned or controlled something. But there's another factor here.
Dumb question, but they're supposed to have domination and control of what? Of who?
Of the
judgment debtor.
Of the judgment debtors. They
Which
have
is
to,
Hellas.
which is Hellas One and Hellas Finance in this case. And again, there is no evidence in this case that any of these entities even touched, sent an email to, called, knew where Hellas One and Hellas Finance, or even knew that Hellas One and Hellas Finance existed. There is absolutely no evidence connecting any of these TPG entities, these appellants, to these judgment debtors. So they're supposed to have not just controlled and dominated, but to have completely controlled and dominated, to have gone beyond normal.
The sense I get is the argument that I heard, maybe I heard wrong, was that to get to complete domination and control, it's like he added them all up to get to that point, right? I mean, that's what it sounds like, right?
100%. What he's doing is he's taking.
And I'm not so sure that the law supports that kind of like.
He's taking dismissed entities that are not even related to TPG, Apex entities, putting it all together and trying to say that somehow or another that results in complete domination and control. I don't think it does result in complete domination and control, but we'd be here all week trying to put all that together. The reality is, all that's left here are the 9 TPG entities, and they did not control or dominate the Hellas One or Hellas Finance, much less completely do it. And then remember, that's only one piece of it. They then would have to show that they use that domination and control sitting there at the driver's seat to commit a wrongdoing. And the wrongdoing is the OM. So what they would have to show is that these 9 TPG entities, or some portion of them, were completely dominating and controlling Hellas One and Hellas Finance. And what they did with that control was marked up the offering memorandum and made it say things that they say are false and misleading. There's no evidence in the record of that whatsoever. And what happened here, I believe, is that Justice Reed was inundated by paper and argument. There were 4 arguments made that day, and I really believe that at the end of the day, there was just so much paper, and there were 9 entities that he went with this idea that there is some kind of collective liability, and that you can take this. I forget the other word that they used to put everybody together. That's a lowercase word used in the offering memorandum that there's no evidence that the TPG appellants had anything to do with the use of that word in the offering memorandum, and it's not a relevant word. It's not a legal doctrine. I mean, again, there's no such thing as collective liability. You can't put all of us together in one place and say everybody's responsible for everything.
I'm sorry, but
No, I'm
didn't
sorry.
this court take the following position that they call it collective liability or a consortium theory, that minority shareholders acting together, can't they effectively exercise some kind of combined majority interest with some kind of control in that way?
I think if you had evidence, I mean, again, this is kind of getting. I don't think that actually fits into the alter ego concept. I think that's really more in the conspiracy concept. This is not a conspiracy case. They touched conspiracy briefly in their opening brief in this case, and then they ran away from it, realizing that they would never be able to ride that horse. So I don't believe there's collective liability in the alter ego context. But if you look at it in the conspiracy context, even there, people who don't do anything can't be part of the conspiracy. In order for there to be a conspiracy, you have to have agreed to do something in connection with the conspiracy, and then you have to actually do it. Here, we did not agree to completely dominate and control the Hellas One and Hellas Finance entities, and we did not agree to do that in order to perpetrate a wrongdoing or a fraud through misrepresentations in the OM. And I just wanted to be clear, I don't think there were misrepresentations in the OM, and I would like to just say at the end that, as I pointed out earlier, but I think I ran out of time, and I'm out of time again, I see, but that, again, this has been ruled on twice by European courts. This is a European transaction that's been blessed by European courts, and I think that we should be, and Justice Reed should be reversed.
We
and
don't
this
lay
case
down
should
on
end
the
here.
job just because
Okay,
the
all right.
Europeans made
Thank
the
you.
decision. All right. And I'm going to give you a little more time since I gave him some more time.
Thank you very much, Your Honor.
Counsel, before you jump into your point, I just have a question about the OM, where it's from Hellas One, right?
It's Hellas Finance as issuer and Hellas One as guarantor.
Right, but when it talks about maybe it mentions Apex and TPG as sponsors, but it doesn't really list either one of those as shareholders in Hellas, or does it?
Well, it speaks of them as a consortium who own and control Hellas. It does. It uses the word consortium there 10 times, and we cite those pages. Consortium is used in other documents by TPG and Apex as well. So the fact is, it pointed out that they were acting together. They were what were called
But
sponsors.
here you're using it as a way of trying to meet your burden collectively through different pieces from different players. Am I wrong about that?
Well, not if all I said to you was look at the word, you would not be wrong. However, the fact is they told the SEC we're doing this all together. We're acting jointly. They did so in that Duchovny letter. They did so in the 13D filing. They did so in the 13E3 filing. Also, their financial advisor, David Prestwich, said that everything on the transaction was done equally between TPG and Apex. That's the record 5209 and 10. Aliberti said it was kind of a 50-50 relationship.
I know, but which TPG? Right?
The end.
I mean, look.
Yeah, no, I understand.
We cannot just dispense with the different corporate entities, right? As your adversary said, there's a reason why LLCs were created, and they are not frowned upon, right?
Two things. Number one, they're not necessarily LLCs, but also the deal teams acted for all of the entities, so that Calice and Aliberti acted for all of the TPG entities and all of the Apex entities. There wasn't a distinction done in how they ran. And Your Honors, you don't write on a blank slate.
But was their individual acts as corporate directors?
No, because corporate directors, they were told, remember what they did here is they took $1 billion dividend and saddled the Hellas entities, the judgment debtors, with $1 billion of new debt. They got to the $1 billion by valuing these securities called CPECs themselves. They valued them at 35 times the value they had the day before the dividend and the week after when they did a Luxembourg regulatory filing. They did the valuation themselves, having been told by their attorneys, you cannot do that unless it's arm's length. They weren't arm's length, they were profiting from the transaction. Okay. So it was a, and then they did what's called a bottom-up valuation where they backed into the number they wanted. So this is not what standard people do who are running corporations. They acted in bad faith. That's the standard. We cite the Letty case. We cite the Motor case in our briefs. But again, Your Honor, what I wanted to say is you don't write on a blank slate here. This is the third time this case has been before this court. The first time talked about, is there standing and is there a claim? This court found there was. The Court of Appeals affirmed. And the Court of Appeals noted that the argument was that they acted together and caused the Hellas entities, which remember are just shells. You have in mind that this, how corporations we might see on the street, these are just a series of shell entities that have no business. They're just used as pass-throughs, and they control these.
We see these all the time.
Yeah, I imagine you do.
We see these all the time, but go ahead.
But so they don't have really corporate reality. They are controlled by these entities who manipulated them. They held out and they got the investment money. They took all of that themselves, and then they left it insolvent. Ian Radner, our expert, who had 400 pages explaining, how they were left insolvent. But anyway, so the Court of Appeals noted that the theory was that they collectively caused the Hellas entities to commit business suicide. So it goes back down to Justice Reed, and ultimately Justice Reed. And Justice Reed, after discovery, we do an amended complaint. Again, they do a motion to dismiss. He denies it. They do a motion to re-argue. He denies it. It comes back before this court. Justice Owing, you were on that case last year. And
I don't remember what I had for dinner last night, but okay.
Well, in that, it was Justice Weber writing, but the panel wrote with no dissent, with the allegations in the original complaint, the allegations in the amended complaint as against the TPG defendants sufficiently stated claims for alter ego liability under New York law at this pleading stage. The pleading was exactly what we've proven, that they acted together.
Yeah, now we're beyond the pleading stage. Now we're at summary judgment. We got volumes and volumes of information now.
But what you have is Justice Reed having spent enormous amounts of time meticulously
And now we will have to do the same thing. Thank you so much.
Thank you very much, Your Honors. I appreciate it.
Rockoff Associates versus Village Place Corp. Okay, 6 minutes.
You
may proceed. Yeah, the whole law firm is here.
They brought all their associates.
Good afternoon, Your Honor.
Good afternoon.
William Geller from Braverman Greenspun PC on behalf of Village Place Corp. This is a case where all of the relevant facts are established by documentary evidence. The plaintiff is Rockoff Associates, who is a partnership who was the sponsor of the co-op here in 1977, and then in 1983 conveyed its interest in the co-op unit here to individuals, who then conveyed it to other individuals.
Right, the certificates are now in the names of the sons, the two sons, and the surviving individual who has a son who has the power of attorney. So it's basically the sons now.
Well, it's the current certificates are the two sons in one family,
right,
and the parents in the other family who have both since died.
So, right.
And over the course of the years, they've changed it from tenants in common to joint tenancies and back.
But that doesn't matter to you. That doesn't matter because it's actually what the certificate says.
The certificate says
it's not the partnership.
It's not the partnership, and significantly, in 1983, the then owners individually said, we are the owners, the two couples.
Right.
We're the owners. We're the successors to Rokoff, and the partnership got out of ownership in 1983 or by 1985. So the question is, Rokoff has come back and brought this case, and our position is that they don't have standing. Documents show they conveyed this decades ago, and why are they back here now? What their claim is, well, under partnership law, individuals can own as nominees for partnerships. And we don't dispute that. The issue here is that the documents show that they deliberately divested themselves of ownership for whatever tax, estate planning, or whatever reason decades ago, and they simply don't have standing to bring this particular case at this particular time. So that's reason one why this entire case should go away. The other issue here is the fact.
That's the question. So, assuming I agree with you,
okay?
I mean, practically, they'll just recommence another action, right, in their own right.
They could. There's a limitations problem with that.
Well, you could either have a relation back argument because you could argue that you already knew what the issue is. It's about the air conditioners, and therefore you can't claim any prejudice.
So what's the point of that? Why don't we just proceed and resolve this matter?
Well, first of all, I think there would be a limitations problem. The other issue is when they brought it, it would have to be all of the current owners that brought it, and I don't know if all four individuals or their state representatives agree with it, or we'll see what happens if the court dismisses it on standing grounds, but there's also substantive grounds to dismiss it. Specifically,
But on that issue, you wouldn't have standing to contest that. Only they would, wouldn't? Isn't that so? You're saying you're not sure that you're saying all of the parties who are owners would have to be a part of this, right?
Right, that if there are four names on the lease, and to bring a claim under the lease, all four lessees are required to sign on as principals. I don't know if they will. But substantively, the issue here is this is air conditioning units located in what is undisputedly a courtyard outside the leased premises. And
That has been used for many years without a problem.
Without a
And it
problem.
only became a problem when the board decided that they were going to move condensers of other units up to the roof for a fee.
Right.
And then some of the board members, 3 in particular, whose windows face the courtyard, said, that's unsightly, I don't like it, it's annoying me, let's assess him double what we assess everybody else. So tell me, how is that proper?
Well, Your Honor, the fact that some of the board members may or may not face the courtyard, that
was the basis for making this decision. And that is not an appropriate basis for a board decision of this kind.
Well, Your Honor,
That basis would not supersede the business judgment rule, as is being argued by.
Well, I would say that the board has the right to assess.
To discriminate against one of its tenants and treat them separately than everybody else?
Well,
The
it's
board
certainly.
doesn't have a right to do that.
I mean, if the question is, these are different units in different places.
Doesn't matter. You can't say, for this tenant, you have to pay double than everybody else.
Well-
That's what's happening here.
I guess there are two parts to that question. One is, was it appropriate for them to say double? We pay double, we said it is. The other question is it appropriate for them to say, you don't have to, can we make them pay at all? Because the issue here is this is a unit that is outside the premises, that there's consistent case law that says something outside the premises is under irrevocable.
Why is this not an appurtenance? Sorry.
Because the test for an appurtenance,
Doesn't it exclusively benefit Unit 1B?
it exclusively benefits Unit 1B, but the issue is it necessary and critical? for
Air
the
conditioning?
For the intended purpose,
I'm sorry, what?
well, the issue is for the intended purpose at the time the lease was issued. In 1977, the
Nobody had
offering
air
plan-
conditioners?
The offering plan said there were no air conditioners here. There were no air conditioners in the unit, and that when Rokoff, as sponsor, conveyed the unit to Rokoff as unit owner, there was no air conditioning. And the fact that years or decades later, they put air conditioning outside the unit doesn't give them the right to have something appurtenant that was not part of the originally contemplated use, the contemplated use that is there in black and white in the offering plan.
Okay, you'll have time to move on. Thank you.
Good afternoon. If it pleases the court, Jennifer Stewart, Smith, Buss, and Jacobs for Rokoff Associates.
To answer my question, why did you bring it as a partnership and not as the individual lessees, the lessees?
This is a small family business that is informally organized. The sons who are now in control are operating informally under Rokoff Associates under that name.
It's a very simple question. Why didn't they bring in their own right as opposed to a partnership? You would be avoiding all this argument here of a standing issue.
They could, and they could amend. We did it to simplify because, frankly, when this action was filed, Ruth, who was on board, was very, very ill. And it was likely that if we brought the case in her name, her passing would delay the case. And we didn't want to risk delaying the case, so we used the name they've been operating under since 1977.
Okay.
Ruth has since passed. David, who was her power
So
of
it wasn't
attorney,
to
is now.
avoid some sort of some sort of
All four
problem, right?
All four of the individuals in interest are members of Rokoff Associates. Gil Kaufman's affidavit explains all of that. It's Gil and Joav and David.
Got it. Thank you.
In the event the court finds lack of standing, we would amend to put it in the individual names. But I think it's a delay for a case that should be relatively easily resolvable. This is not layers and layers of shells. This is not $1 billion judgment.
Not like the other one.
Thank goodness.
Not like the other
How many
case.
could we, those could be.
9 entities.
So many.
You're so lucky.
This is a 1977 lease. The first AC unit was installed in 1980. The second one in 1994. They serve Unit 1B. They have always served Unit 1B.
But did you have those
They continue to serve.
condensers outside since 1980 when you installed the first air conditioning unit?
They've been in the exact same place on the exact same concrete block, in the exact same courtyard. They've operated without incident until this issue of imposing new charges for appurtenances we've been using since 1980.
So let me just say, to play devil's advocate, now that the building has passed the resolution inviting their tenants to put their condensers up on the roof, and they are charged a lesser fee, would you agree that your client will have to pay a fee? The question is, should they have to pay a double fee? Do you
Well,
agree
all
with
of
that?
this is outside the record.
Right.
The roof resolution doesn't affect the courtyard.
Well,
I think my clients have a strong legal argument that the lease precludes a fee. That said, there has been a proposal on the table where they would agree to a fee equal to what's being charged on the roof for years now. As an aside from that, in point of fact, the same board members who don't like the condensers they can see pushed the resolution to put the other condensers on the roof. And as far as I am aware, on information and belief, exactly 0 residential tenants have elected to put condensers on the roof.
Are there
So
other
nobody's being charged a fee and nobody's paying a fee.
The other condensers of the other units, where are they then?
The
Are they
window
hanging out
units
of the window?
predominantly. This was to make available sort of central air for your apartment because you can put the condenser on the roof or a split system.
Got it.
And people are sticking with the window ACs that work for them.
Got it. Okay.
Unless there are questions?
Yeah, I thought there was something on the record where when the resolution was being considered, the representations were made to the Rockoff Associates that they would be exempt from any potential fee at all, particularly because they were not root condensers, but
Yes, the managing agent specifically represented to Gil in order to get his vote
so
that this would not affect them in any way. And as it turned out, it did.
Okay.
The one other point that I had intended to make was that this is a motion to dismiss. A motion to dismiss where, to be dismissed on documentary evidence, it has to utterly refute all of the factual allegations. Village Place's arguments ask this court, as they did the trial court, to adopt their version of the facts. But that's not what's appropriate on a motion to dismiss.
Thank you.
Of course.
So just a few responsive points. As I understand it, now there is the idea here of this roof amendment was to allow to put something in the offering plan in the proprietary lease so that if a unit owner wanted to put a condenser on the roof, they could. It was an amenity to their unit owners, and my understanding is now one of the unit owners is taking advantage of that. But it wasn't saying these are existing units.
I mean, it really didn't deal with their unit at all.
It didn't deal with the unit.
So it's you just decided unilaterally to start charging them this money because nobody was putting their things on their roof, so you weren't getting any.
No, well,
but I mean, I don't understand if you have a proprietary lease there for 40-some years and it's been in appurtenance, how all of a sudden you start doing that. And if you do that, you do it at such a larger amount than what you were going to do for the other people.
Well, again, there are two questions. One, did they get the amount right? And two, can they do this at all?
So, I mean, if this is in fact a motion to dismiss, how are we going to dismiss the case at this stage?
Well, because the offering plan, which is Rokoff's document that says very clearly, and this court's several cases say, you look at the offering plan to see what's in the lease. And the offering plan was very clear in 1977 when this space was created, it had no air conditioning. And the fact that some years or decades later, it decided to put air conditioning in.
According to her, 3 years later.
Well, however many years later, the fact that they've been able to get away with it for 30 or 40 years is good on them, but they can't unilaterally expand the space that was in the offering plan that they said was there by putting something.
I can't imagine that they got workers to go onto the courtyard area without permission of the building and management, but that's neither here nor there.
My understanding, well, thank you, Your Honor, I appreciate it.
All right. LMM Capital Mill Point versus Mill Point. Okay, you have 7 minutes. You may proceed.
Thank you, Your Honor. Good afternoon. Samuel Butt for Schlamm, Stone, and Dolan for the plaintiff appellant LMM Capital. May it please the court, in this case, LMM sourced the deal with defendant E&M, introduced defendant Millpoint to the deal. There's no question that Millpoint was subject to a non-circumvention agreement and that Millpoint and E&M proceeded.
The question I have is the release. How broad is this release that the LMM signed and got in exchange for over $420,000? Sorry, less than the 1.3 billion. I got confused. But so how isn't that release broad enough to encompass your fraud claims?
Respectfully, Honor, no, for a few reasons. First, the $420,000, I think it's important for the court to understand that under LMM's letter of intent with E&M, it was entitled to $400,000 in the event the transaction did not occur, no matter what.
Why did you even have to sign a release if you were entitled to it under the contract anyway?
Well, we allege in paragraph, I believe it's 181 of the complaint, defendant E&M and defendant Kelly, who was the president, threatened not to pay the $400,000, even though he was required to under the letter of intent, unless this release was signed. And as we've alleged, the change of the 400 to the 420,000 and the payment of it instead of one lump sum, but of 300,000 and then 6 installments of 20,000 was part of the defendant's efforts to try to insulate themselves.
And correct me if I'm wrong, but you're proceeding under the argument that this release, first of all, it shouldn't have been considered on a 3211 because you're challenging or you're arguing that it was fraudulently induced, right? That you were fraudulently induced to sign and execute this release, right?
Correct.
Putting that aside and just say, okay, let's just say that Supreme Court properly considered it. Now, and then let's also assume that your fraud claims are encapsulated in that release. What's the separate fraud that would support a fraudulent inducement claim?
So, Your Honor,
Did you follow that? It was a lot.
I believe so. I will try to answer the question. If I don't, please, of course, let me know. The LMM's claims here are not premised on fraud. They are for breach of contract and tortious interference. The claims are that Mill Point breached its non-circumvention agreement and that E&M tortiously interfered with the relationship with Mill Point, and Mill Point tortiously interfered with LMM's relationship with E&M. But the fraud is...
okay, got it. You get it.
The fraud is separate. The fraud was solely to induce LMM to enter into the release because the defendants knew that Mill Point was subject to the non-circumvention agreement, and if they did a deal together, certainly Mill Point would be subject to a breach of contract.
I don't understand how that is the basis of fraud. You knew you had a non-circumvention agreement with Mill Point, so you know Mill Point knows about the relationship, right? You have recourse. If they violate that, you can go after Mill Point. Violate that, you can go after Mill Point, right? You have an agreement already signed by them saying if we don't close, we have to give you $400,000. So where were you fraudulently induced? You had two causes of action, one against the E&M, is it?
E&M.
E&M, who said if we don't sell to you, we're going to give you $400,000 as our breakup fee, right? I don't understand where the fraud is. You had, at the point where you believed that either Mill Point was double-crossing you on the non-circumvention agreement, you could sue them. If E&M doesn't pay the breakup fee, you can sue them. Where is the fraudulent inducement? You knew everything there was to know.
So why did you sign the release then? I mean, exactly. I mean, that's the
Yeah.
question.
I think
there's like you're saying that they fraudulently induced me to sign this, when exactly as my colleague said, you had two very good documents out there to allow you to proceed.
You signed because you wanted the money now.
So
You didn't want to have to sue and wait for the money and pay lawyers' fees. I get it. But how does that equal fraudulent inducement? I'm at a loss on that one.
So, Your Honor, I have a few responses to that. The first is the court should look at the timing. The release was signed on April 21st of 2021. LMM did not know that Mill Point and E&M were doing this deal behind its back until June of 2021.
Wait a minute. When did you have them sign the non-circumvent agreement? In February of 2021. So
Correct.
obviously, there was something milling about, no pun intended, right, that made you go to Mill Point and say, wait a minute, this is our deal. So you don't approach them, this is our deal, and you and I are going to enter and we'll do it together, or whatever the arrangement was going to be. But obviously, something alerted your company that we need to go to Mill Point because they're trying to get into this deal, right?
No, respectfully, that's not correct.
You get into a non-circumvention agreement, you pick a company out of a hat, and you say, you, don't mess around with my deal. Something made the company ask for a non-circumvention agreement with Mill Point.
That
With
was
some information, right?
That was because at the time, in February 2021, LMM was seeking outside investors for the deal, and it required And it's just standard in the industry. If you're introducing a party to a deal, they sign a non-circumvention agreement for this exact purpose, so that that party then does not go behind your back and steal the deal out from behind you or under you. The other point I'd like to make is it is not clear even that the release would cover Mill Point or Kelly.
Well,
First,
you mean the release?
yes.
Well, doesn't the release define company release parties as the company's past, present, and future affiliates? The company and the company's affiliate predecessors, successors, assigned, the directors, et cetera, et cetera. Wouldn't that make Mill Point, who took over E&M, a successor affiliate, a company affiliate? I mean, it fits squarely within the definition of that release.
I'll let you answer, please.
Thank you. The release has to be fairly and knowingly made. It's axiomatic. You cannot release. It cannot be fair. A release cannot be fairly and knowingly made if you do not know who the party is going to be. And respectfully, the reason to include future affiliates is so that a plaintiff can then not sue a second company when it's released company A if company B then becomes an affiliate. It is not to preclude, for companies A's conduct, it is not to preclude a plaintiff from suing company B, which it has no idea will ever be subject to this release for company's B conduct just because it becomes an affiliate of company A.
Okay, you'll have time on rebuttal.
Thank you.
May it please the court, Julia Buskin, Schulte, Roth, and Zabel for respondents, Mill Point Capital and E&M Logistics, Inc. Your Honors, this is a classic case of bargainer's remorse. Plaintiff is a sophisticated party, represented by counsel. They negotiated the termination agreement.
There are three, in my mind, there are three agreements here. You got the letter of intent, which has a breakup fee. You have the non-circumvention agreement that your client signed. And then you had this release that was signed, right? And the whole thing, it's now, in order to, you guys are relying on the release itself to get rid of this case. And they're arguing, and the argument I hear is it was fraudulently induced in terms of me signing this release. Okay, let's just say, because we know under the case law that if the release is broad enough to cover fraud, and let's argue it does if there's a separate fraud claim, then to back up the fraudulent inducement claim, you gotta plead a separate fraud, something distinct and not part of that release. I'm trying to figure out what that is because my notes here indicate that after the deal, after plaintiff selected Tenex, a month later, Kelly, your guy, tells the plaintiff, you know what, I want to just terminate everything. I want to give, I'm done. I don't want to go through with this, and let's sign this release. There was nothing and Nestle doesn't want to do these deals. I mean, at that point, where's the justifiable reliance? Like, he says that, the plaintiff's principal says, I want to call Nestle and whatever. Nothing stopped them from calling and figure out what was going on, right?
That's all exactly right, Your Honor. And I, too, have searched in vain for the separate fraud that's required under Centro and its progeny. Centro tells us that the fraud needs to be alleged that is separate from the subject matter of the release. What's the subject matter of the release here? It releases all manner of actions, causes of action, et cetera.
Pretty broad, right?
Yes. Arising out of, related to, connected with, or incidental to the letter of intent or the transactions contemplated thereby. The fraud that's alleged here is twofold. One, that E&M misrepresented that its major vendors would not agree to a private equity deal.
And then went around and actually did go into business with a private.
That's correct, but that's not relevant, Your Honor, for the following reason. The letter of intent provides that E&M could have terminated after the 90-day exclusivity period, which we're outside of unquestionably, for any reason whatsoever. So they frankly could have told a plaintiff that they decided to walk away for any reason whatsoever, whether it has to do with their major vendors or not. So it's not in fact relevant that they pivoted and ended up doing a private equity deal.
They could have waited 90 days, not have to have gone into paid the the 200,000 or whatever it was breakup fee, and then gone and did what they did anyway. They just wanted to move it faster.
So the breakup fee was 400.
Yeah, that's not how I read that. I read the LOI to say that E&M was offered 74 million to acquire their company, right? And that they would not consider any alternative transactions for 90 days. And that provision was a meaningless provision, in my mind. It was absolutely meaningless, because later on in the LOI, you say, notwithstanding anything above, defendant agrees to pay the plaintiff investor breakup fee of 400 if defendant elects not to close, including if company receives a better deal. So to me, from the very beginning, E&M intended to continue to look for and seek better offers.
As it was permitted to under the LOI, and as it unquestionably released any claims under the LOI pursuant to the release. And again, the subject matter of the release is so broad that it unquestionably, to my mind, encompasses the fraud that's alleged here. There is no separate fraud that's being alleged. Yes, Your Honor?
The claim fraud is that this Kelly guy told LMM that Nestle and for the second one, whatever, would not go with private equity company. That was the fraud, and then afterwards they went and did the deal with Millpoint. But then there was information somewhere in this process where Nestle did sell to some other company one of their interests to a private equity group, correct? Graham Foods, did I get that right?
I believe you're referring to an email in which plaintiff emailed my clients and mentioned, I don't have it in front of me, but in sum and substance, we know that Nestle's done deals with private equity firms.
If they saw, if that particular position was so ironclad, and yet they learned that some other deal with another, that should have given them a heads up. In other words, they were not lulled here in doing their due diligence.
I think that's exactly right. And I also think it's important to note that Mr. Kelly also advised plaintiff, if these vendors change their mind in the future, we'd consider doing a deal with you, but we're not willing to put it in writing, which put plaintiff on notice, hey, we're not in any exclusivity. Everybody was on the same page, or at least had the same awareness of the following fact. It's at least in the realm of possibility that a private equity deal could happen with E&M in the future. And the reason that everybody knows that is because it's pleaded on the complaint, right? They said, Mr. Kelly said two things as alleged. These vendors, they're not going to agree to a private equity deal, but if they change their mind. Plaintiff is
and the LOI, the language in the LOI made it very clear that this was not exclusive.
Exactly. And plaintiff is misconstruing, I think, the significance of that representation and trying to twist it into a representation that E&M under no circumstances was ever going to do a private equity deal. It says, if it knew that there was going to be a private equity deal, it never would have entered into the termination agreement. That doesn't make a lot of sense because they had no basis under the LOI to force E&M to do a deal with them. But even putting that aside, the release is obviously enforceable. There is no fraud that's been alleged separate as central
Millpoint is an affiliate under the release.
Yes, I think that that's clear under a plain reading of future affiliate. And I want to mention 2 points in that regard. LMM tries to ascribe some nefarious intent. We E&M, that is, inserted this future affiliate provision. There's nothing in the record to support that. Keep in mind, this is mutual. Everybody got the same releases. LMM got the same releases of past, present, and future affiliates that my clients got. Both sides also got the same releases of successors, assigns, and predecessors. This is the definition of, this is what it means to enter into a release of unknown claims. Unless your honors have any further questions, I think I'll stop there.
Thank you.
Good afternoon, Your Honors. Mark Sabo for Defendant Kelly. May it please the court.
So let me ask you a question. Sure. I understand why your client would want the release, because the letter of intent doesn't release anybody from anything. The letter of intent just has a breakup fee of $400,000. So, you know, in your mind or in your client's mind, or a good attorney's going to say, got to get a release, right?
That's correct.
But before that release is signed, at least in my mind and my notes here, there were a lot of warning bells that went up, right?
Your Honor, there was...
I mean, the fact of the matter, one of them, according to my notes, is your client said when it was asked by the plaintiff's principal, I want to talk to Nestle, I want to talk to the other guy. Your client says, I'm not arranging that deal. I'm not arranging that meeting.
He wasn't going to arrange it, and that should raise any issues as to justifiable reliance. But even further, I'll point out how it just shows that there was no justifiable reliance here. Plaintiffs makes a big deal about the fact that after it was signed, they sent a note to Millpoint about the confidentiality, and Millpoint responded, "Are you done with the deal?" And they responded, "No, we still would like to pursue a deal with E&M." And they've used that as a way to say, look, Millpoint should have known that the non-circumvention was still in place. But how could they have ever thought that they were going to do a deal with E&M going forward if they justifiably relied that Nestle is never going to do a deal with a private equity firm? I mean, it just doesn't, you can't reconcile the allegations in the complaint with the allegations of fraud. Ultimately, there was no justifiable reliance there. And just to point to they've raised that Kelly wasn't a beneficiary of this release, which is preposterous. I mean, he's the majority shareholder director of E&M, president of E&M, and they've pointed to the fact that the parties in the release are listed as potentially the affiliated parties. Which would be their subsidiaries there, but they apparently didn't look at the signature page of the LOI and of the release, which Martin Kelly signs as president of E&M and its wholly owned subsidiaries. So I will leave you with that.
Thank you. And you have 2 minutes.
Thank you, Your Honors. So with respect to the separate fraud, there is a separate fraud here. Centro required that there be a fraud separate from that which was the subject of the release. But in Centro, the case was plaintiffs had brought a fraud claim based on fraudulent financial statements that induced them to enter into an agreement to sell, and part of that agreement was the release. Here, there is no such separate fraud based on financial statements or anything else. The fraud only related to the release. The Sillam case is on all fours with this case. In that case, the defendant law firm had made representations that they no longer had any
See, what
clients.
I'm having trouble with is that the fraud, the separate fraud versus the fraud that you need to support a fraudulent inducement claim, those facts seem to me to be the same on both sides. Whereas Centro says, you need different facts. If your fraud claim falls, your fraudulent inducement claim can still go forward if you have something different kind of fraud. And the way I see it, I mean, I'm just looking at this, it just sounds like it's the same facts on both sides. You don't have different facts on both sides for both frauds.
Well, again, there is no underlying fraud claim here. The fraud claim is the fraudulent inducement.
Right, so I'm glad you said that. There is no underlying fraud claim. Right, so now what are the allegations to support the fraudulent inducement, right? And you're saying that he lied to you, whatever. Okay, let's say I agree with that. But to go further, you have to show justifiable reliance. And my notes said there's some alarm bells that went off before you signed that release. The fact that he said, I'm not arranging that meeting, showed him that was a big alarm bell. Don't you think?
So, Your Honor, the question of justifiable reliance, first of all, is an issue of fact. It's not one that should be decided on motion to dismiss. We cite several cases in our brief in that regard, and there were no alarm bells. It was not until June that LMM had any idea that E&M and Millpoint were doing a deal. Just because somebody doesn't want to arrange a phone call, that's a very, in my view, shaky ground to say that they should have done more. They had reason to suspect it was going to be Millpoint, which was subject to a separate non-circumvention agreement. And I just want to quickly say, whether or not E&M could have done a deal with a different private equity firm or anybody else after that 90 days, it could not have done a deal with Millpoint without facing liability because of Millpoint was subject to the non-circumvention agreement, which was separate from the LOI. Thank you, Your Honors.
Con Edison versus East Coast Power. Judge Oing is recused. If there is a tie, the court will follow its appellate division rules in vouching a judge. All right, you have 5 minutes.
May it please the court, John Perlman for the plaintiff appellant, Con Edison. A fiduciary duty is a condition precedent to an accounting cause of action.
Yeah, but this really isn't an equitable accounting cause of action. Essentially, you want roughly $6 million from East Coast, correct?
Correct. Con Edison is...
Con Ed, you represent Con Ed, right?
Correct.
You want $6 million from them.
Under a breach of contract claim.
Right.
Correct.
Now, they want to say, okay, you've controlled the meters, you did the billing, you did everything with respect to East Coast customers, which were your receivables. So why shouldn't they be able to get the data? This is what Justice Ostrager was telling you with his orders. Show them the breakdown of the $6 million. Why is that unreasonable?
That's discovery as to a breach of contract claim. That East Coast is entitled to, that East Coast received as part of the breach of contract claim. The counterclaim that's the subject of this appeal, however, is something different. It's not East Coast breach of contract counterclaim.
No, it's all it really means.
No,
you're elevating form over substance. All it really means is they want you to do an accounting for damages purposes. That's what Judge Ostrager said on the record. He said, just give them the data. I don't even understand it.
That's the important distinction. Article 31 discovery on a contract claim is Con Edison giving East Coast the data. That Con Edison did, and accounting is something different. The party who is obligated to provide an accounting has to do more than just giving raw data. The party having to provide an accounting needs to organize the raw data, needs to summarize the raw data, explain the raw data, do something other than give the raw data. The party who gives an accounting has to explain what the data means and do other things to do the affirmative conduct of accounting. Giving raw data is what a breach of contract counterclaimant is entitled to. That is what Con Edison did, and East Coast received it.
Wouldn't you ultimately, if you're going to try this case, hopefully win this case, wouldn't you have to wouldn't you have to put forward your documents, your backup to your claims in a way that you explain it? Don't you have to do this ultimately to win your case on trial?
Because it's not like you're going to give raw data to either a judge in a bench trial or a jury and say, you figure it out, right? You're going to outline exactly how you reach the $6 million number they owe you. They owe me this because in this category, they owe me this, and here's the breakdown. I don't understand. As my colleagues have said, this is going to have to get done anyway if this goes to trial, right? So I don't get it. What's the problem?
There is no problem.
No, there is a problem because the judge has asked you to give it twice, and you have not done it in the way that the judge wants it done.
That's what was. Well, there are two things. Number one, that's what East Coast avers, and East Coast is not correct. Insofar as justice...
The court ordered it twice, which means the court was not happy with what you gave the first time.
That's what I'm getting at.
Okay.
And as far as that goes, Con Edison addressed Justice Ostrager's comments. So right now, what Justice Ostrager said has been addressed. So as I stand here today, and as you sit here today, what Justice Ostrager remarked about has been cured. As far as Your Honor's initial question of won't you have to do an accounting to prove your case, no, they're two different things.
No, not necessarily. Look, it has to be broken down in a form that the trier of fact can digest. Can we agree on that?
Correct, Your Honor.
Okay. You're not going to throw just raw data about, I don't even know the acronym for how you measure gas units, for instance, right? And you have to assess how many gas units you got versus what went out. That's part of this calculation, right?
Generally speaking, correct.
Yes, and with $6 million worth of money due you, there's got to be figures broken down into where are those numbers? From what?
That's not the correct analysis, respectfully, Your Honor. When
My
Con
favorite
Edison,
word. Go ahead.
Excuse me?
Go ahead.
When Con Edison says that $6 million is owed, it could produce a witness. A witness could talk about the way meters work. Meters register electricity.
But you're going to have to produce these documents. I mean, we don't just let somebody get up there on trial and talk about how you owe $6 million. I mean, you would put in documents to support it.
That's correct, but that's not the question I was answering. The question I was answering was, what are you going to have to do at trial? As far as producing to East Coast raw data, Con Edison has done that. That a breach of contract claimant or defendant or counterclaimant is entitled to, and that's what they...
So is your position that what they're asking for at this point is too soon?
It's too...
Because you're going to have to turn it over anyway, but you're saying you don't want to do it now.
Well, no, they're two different things. Number one, East Coast has to establish that it's entitled to an accounting before it gets the separate exercise of providing an accounting.
And you have to establish why you are owed $6 million, how and where, and the numbers. That's what you have to establish. But you'll have time on rebuttal.
Thank you.
Good afternoon. My name is Jim Brand, representing the respondent. May it please the court. I'm going to go a little bit out of order. Con Edison's original primary brief spent half its time trying to attack the validity of Justice Ostrager's discovery orders. They said that they were improper. These are my words. By the time we got to the reply brief, they were contending that the respondent's position was on fiduciary duty, that the fiduciary duty claim was supported by the fact that we alleged purportedly that meter readings were improperly done. That's just absurd. Justice Ostrager properly denied the motion to dismiss the fourth counterclaim for inequitable accounting. He had before him the counterclaims and the specific allegations made by respondent therein.
Excuse me, counsel, did they appeal from before appealing this order, did they appeal from the earlier discovery orders?
No.
Okay.
Not at all.
So if you look at what the judge said on the May 11, 2022 transcript, he said, and I'll cut to the chase, in which they can intelligently discuss a mediated resolution is for Con Ed to provide this accounting. He uses that term. The defendants would be entitled to it in the ordinary course of discovery. All I'm doing is expediting this by a month or two. That is the direction of the court. So we have a court order not directing a data dump, but an accounting. As my colleagues pointed out, categorize the $6 million in the right columns, where it came from, the backup, and explain it. Would that be a fair understanding of that order?
Yes.
It was never appealed.
None of it. There were multiple orders issued by Justice Ostrager about ordering both accountings to take place. Let me go a step further, okay? What Con Edison ultimately produced in its first accounting and its second accounting was not even an accounting. They themselves called it, I believe this to be the case, East Coast customer account summaries. Okay, so in other words, what they didn't include were all the credits due respondent for putting power into the system, and credits due when that power wasn't used, okay, and a whole host of other things. I've briefly touched upon, I understand, I briefly touched upon the fiduciary duty allegations. Let me go a step further, which is, the bottom line is whether a fiduciary duty exists depends upon the party's relation, okay? It doesn't depend on contracts. Con Edison falsely said that, well, they accurately said that there were multiple contracts and claimed that none of them required let me look at the exact language. None of them imposed a duty to account, okay? First of all, there's no evidence in the record to support that. I would also argue that I don't think it's accurate. And the third thing is Con Edison only put 2 contracts into evidence, and they were heavily excerpted by its counsel, predecessor counsel, three removed from Mr. Perlman, and excerpted to the point where there was 1 page from each of the 2 contracts that was put into the record, okay, by Mr. Kim, I believe. If you could just bear with me just 1 second, please. The discovery orders were not final accountings, and Justice Ostrager never intended them to be. What he realized, and what I believe it was the May 11th transcript order indicated, was he realized something was very amiss, and that Con Edison was being very reluctant to turn over any information, okay, much less documents, much less information, including after respondent went out of business in July 2020 and ceased being an escrow, okay, Con Edison continued to take various actions, themselves constituting acts which would ground a fiduciary duty, that they never, with our former customers, that they never disclosed at any point to respondent, and we only learned thereafter. This is not in the record, but we only learned thereafter that these things had taken place. Con Edison, can I continue?
I'm gonna give you another 30 seconds.
Thank you. On the record, page 69, there's an email that was distributed by Con Edison to ESCOs generally, where they indicated that for several months they were undertaking internal discussions. Those internal discussions impacted materially, particularly from a fiduciary duty standpoint, but also from a contract standpoint upon my client, okay? And for a number of months, they didn't even involve the PSC.
Thank you.
Thank you.
You have 1 minute.
How Con Edison would present its evidence at trial, what demonstratives it may produce to a jury, that's its prerogative and a separate issue of whether it owes the obligation during discovery to do a similar exercise, not as part of a jury presentation, but for East Coast, for someone to whom allegedly Con Edison owes a fiduciary duty. So everything that Your Honors described, Con Edison indeed may want to do that for its own self-interest to pursue its breach of contract claim. That's its trial strategy. Those are the demonstratives that maybe will make, but those are things that Con Edison will do on its own to persuade a jury to rule for it. That's completely different of the obligation right now, before there's a trial, to do the same or similar exercise for East Coast benefit. In order to be obligated to do those things, Con Edison has to be East Coast fiduciary, which it is not.
Thank you.
Thank you.